Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Somebody tell me to use the door, don't try to jump through the window.
Announcements by the President.
Honorable Senators have granted leave of absence to Senator the Honorable Franklin Can, who is ill. I am awaiting the instrument of appointment, and therefore I will ask that we return to this item on the order paper when I receive it. Honorable Senators, I have received the following correspondence from the Speaker of the House of Representatives. December the 16th, 2019, Dear President of the Senate, Membership of Joint Select Committee. At a sit-in held on Monday, December the 16th, 2019, the House of Representatives agreed to the following resolution. Resolved that the following 6 members be appointed to serve on the Joint Select Committee appointed to consider and report on the Cannabis Control Bill 2019. Mr. Faris Al-Rawi, MP, Mr. Stuart Young, MP, Mr. Fitzgerald Hines, MP, Mr. Terence Dialsing, MP, Mr. Rushton Paré, MP, Dr. Tim Gopi Singh, MP. I request that the Senate be informed of this decision at the earliest convenience, please. Thank you. Respectfully, Bridget Mary Anisette George, MP, Speaker of the House of Representatives.
Bills brought from the House of Representatives, the Administration of Justice, Indictable Proceedings, Amendment Number 3 Bill, 2019, in the name of the Attorney General as listed on the order paper. On the supplemental order paper.
Attorney General.
Madam President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Administration of Justice Indictable Proceedings Amendment Number 3 Bill 2019 be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the bill be taken later in the proceedings. Those in favour say aye. Aye. Those against say no. The ayes have it. The next stage of the bill will be taken later in the proceedings.
Papers.
Mr. Vice President.
Madam President, I have the honor to lay the following paper as listed on the supplemental order paper in my name. The delegation report of the 140th Assembly of the Inter-Parliamentary Union, Doha, Qatar, April the 6th to the 10th, 2019. Thank you.
Reports from committees.
Acting Leader of Government Business.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The second interim report of the Special Select Committee on the Evidence Amendment Bill 2019. I thank you.
Senator De Freitas.
Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018, 5th Session, 11th Parliament.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, there are 7 questions on notice. The government will answer all 7 questions today. Thank you.
Senator Mark.
Thank you. Thank you, Madam President. Question number 11 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you, Madam President. Madam President, once again, Senator Mark's information is incorrect. The ministry's procurement functions were not outsourced to any consultant. Presently, the agency has a manager procurement who's acting, who ensures the efficient functioning of the unit and that the strategic and operational activities of the department are monitored and achieved. And as such, Madam President, based on this answer, the part 2, therefore, is not relevant.
Senator Mark.
Could I ask the Honorable Minister if he can share with the Senate what were the reason for the dismissal of these 6 persons?
Well, Senator Mark, based on the response given, I don't think that question arises. Yes? Yes, of course. Yes. Senator Mark, next question.
Yeah, question number 22 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, in the case of the circumstances of April 14, 2019, the flight was the last flight out of Port of Spain and had a large no-show factor. As a result, Caribbean Airlines opened the flight for its standby passengers as in accordance with their normal process. As the passengers attempted to purchase tickets at the ticket sales counter, a confrontation occurred with airline staff. This confrontation created an unsafe situation which warranted the intervention of airport authority security. Due to the unsuccessful efforts of the airport authority security to control the standby passengers, the airport authority security, along with the airline's airport representative, agreed that the sale of tickets would be stopped. In addition to this, the airline crew's duty time, which is the period of time a flight crew can legally operate a flight, as outlined in the Caribbean Airlines guidelines for cabin crew and flight crew, was approaching its limitation and would have caused the flight to be cancelled altogether if the airline continued to sell tickets and check in passengers for this flight. On April 14, 2019, the cabin and flight crew had 9 hours from the time they started their duty with an end time of 2:30 a.m. on April 15, 2019. The crew completed their rotation at 1:56 a.m. on April 15, 2019, 34 minutes before their duty limits. Caribbean Airlines policy is to facilitate all passengers up to full flight capacity. However, in situations where security and safety may be compromised, the airline's airport manager can exercise the discretion to dispatch flights with less than full capacity. The company maintains its policy and procedure for safe operations of the airline and encourages its passengers to abide by them. The airline cannot be held responsible for the unruly behavior of passengers. Thank you, Madam President.
Senator Mark.
Yeah, Madam President, can I ask the Honorable Minister what led to the confrontation at the material point in time?
Minister.
Madam President, as I indicated in my initial response, the standby passengers in attempting to secure seats on the airline and purchase tickets to fly to Tobago became unruly, and the airport authority security had to intervene.
Senator Amin.
Thank you. A follow-up question. Through you, Madam President, the Minister, has Caribbean Airlines considered revising their system for procuring standby tickets based on this incident and the recent rushes that we have had at the airports?
Minister.
I am not aware that Caribbean Airlines has come to the conclusion there's anything wrong with or that their system is different from the normal approach taken by airlines in respect of standby passengers, Madam President.
Senator Mark.
Can the Minister say or inform the Senate whether any action was taken to facilitate the passengers who were unable to get onto that flight on that evening? Can you indicate to the Senate what steps did Caribbean Airlines take to facilitate them in one way or the other, accommodation inclusive?
Minister.
Madam President, I'm unable to respond to that question.
Senator Mark.
Can you advise the Senate when you'll be able to respond to this question?
Minister.
President, if the member poses a question, we can provide a response.
Senator Mark, next question.
Question number 23 to the Minister of Finance.
Minister in the Ministry of Finance.
Madam President, for fiscal 2020, the Sentencing Commission has been allocated a sum of $2,148,000 under Head 23, Ministry of the Attorney General and Legal Affairs, to meet expenditure as follows. Personnel expenditure, $895,000. Goods and services, $1,103,000. Minor equipment purchases, $150,000. The Ministry of Finance will release funds for the Sentencing Commission as soon as it is in receipt of a request from the Ministry of the Attorney General and Legal Affairs for this head of expenditure. Madam President, my understanding is that the Commission is seeking to secure accommodation and to get itself ready to provide its services, and to date has not requested a release from the Ministry of Finance.
Senator Mark.
Can the Honourable Minister indicate where the Commission holds meetings at this time? Seeing that they are searching for accommodation, where does the Commission meet at this time?
Minister.
Madam President, the AG would be the more appropriate person to whom to direct that. The Ministry of Finance does not have that information.
Senator Mark.
Can the Honourable Minister indicate what steps have been taken by the government to speed up the acquisition, rental, or otherwise, as it relates to accommodation for the Sentencing Commission?
Senator Mark, I won't allow that question because in light of the question posed and the answer given, so it's not material to the question posed. So do you have another question?
Can I ask, Madam President, of the $2 million allocated thus far, can the Minister indicate how much of that sum has been released to the Sentencing Commission thus far?
Minister.
As I indicated previously, Madam President, of the sum allocated to the Commission, the Ministry of Finance has received no requests for releases to date.
Next question, Senator Mark.
Question 24 to the Minister of Health.
Thank
Minister
you.
of Health.
Thank you very much, Madam President. Madam President, once again, Senator Mark's question is based on a false premise. The Molecular Biology Laboratory for the Eric Williams Medical Sciences Complex was delivered and was commissioned during the period June and August 2019 with the supporting testing and training of staff. I thank you, Madam President.
Yeah. Senator Diana Ryan.
Thank you, Madam President. Question number 50 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, the process of introducing transfer pricing legislation includes an assessment of the current taxation framework, consultations with key stakeholders, including taxpayers, legislators, policymakers, management staff, IT personnel, auditors, lawyers, judges, government ministries, and civil society. Development of transfer pricing policy with the input of transfer pricing experts to guide the drafting of primary and subsidiary legislation and regulations, and training and capacity building, and the establishment of a transfer pricing specialist team or unit for the administration of the legislation upon proclamation. The Ministry of Finance is in the process of finalizing the implementation of an appropriate transfer pricing framework and once completed, will aim to introduce such legislation in the 5th session, 11th Parliament. Thank you, Madam President.
Senator Mark.
Can I ask the Honourable Minister, is the government going to produce a policy paper on this very important question of transfer pricing? Is there a policy paper that will be generated by the government on this particular matter?
Minister.
Madam President, the government has an internal policy. I am not aware of whether or not there is intention to circulate that prior to the laying of the draft bill.
Senator Mark.
Can I ask the Honourable Minister, is there a particular time frame you anticipate, seeing that we have a very short period next year, for the laying of this bill for deliberation in the Parliament? That is the transfer pricing legislation. Is there any time frame?
Minister.
Madam President, I can be no more specific than I was in my original response at this time.
Senator Mark.
Ask the Minister whether the government has abandoned this particular thrust to introduce legislation in this Parliament, having regard to the fact that 4 years ago, that position was enunciated. Is it fair to conclude that the government has abandoned that plan to introduce legislation on transfer pricing?
I think it's fair for me to say that that question is not allowed. Any other questions, Senator Ma? Okay. Next question, Senator Richards.
Thank you. Welcome back, Madam President. Good morning, everyone. Question number 57 to the Minister of Health.
Thank you very much, Madam President.
Minister of Health.
Madam President, part 1 of the question deals with deaths due to influenza. The answer is as follows. For the year 2013, no data is available regarding deaths due to influenza, which is a tragedy. For 2014, again, no data available, another tragedy. 2015, no data available, tragedy upon tragedy upon tragedy. We started collecting data in 2016. Under this administration, no deaths. 2017, none. 2018, 7. 2019, as at December 7th, 32. There were 6 reported deaths for the periods, for the 6-month period as asked, between April 30th to October 31st, 2019. Part 2, the number of reported suspected influenza cases as of December 17th, 2019 is 3,232, which is 28.8% lower than the 4,544 cases for 2018. Part 3. Yes, our public health institutions are adequately stocked with influenza medication, as 100,000 doses of vaccine were received in November 2019. As of December 9th, 2019, 52,900 doses were distributed and 33,101 doses were administered at various public health institutions. I thank you, Madam President.
Senator Mark.
Is it?
Sorry.
Was it good?
No, Senator Richards.
Thank you, Madam President. Thank you, Minister, for the answer. Would you be able to, and just for public information, reiterate to the public, the vulnerable groups, so that they know they should access the information, the vaccines, please?
With pleasure. Pregnant women, the elderly over 65 with diabetes, etc., children between the ages of 6 months and 5 years. And Madam President, it is regrettable that Trinidad and Tobago has now tarnished its reputation in the international health environment by a very unfortunate statement, and I have the Hansard of Wednesday 11th, where Dr. Tim Gopi Singh, speaking on behalf of the UNC, said, "And as from the role of a gynecologist, I am still to determine whether I should recommend a pregnant patient for the vaccine, because there is a raging controversy for children, and children are getting a lot of complications from the vaccine." Madam Speaker, this statement by the UNC and MP Tim Gopi Singh has tarnished the international reputation of Trinidad and Tobago, because I got calls from Vancouver, Washington, the CDC, London, not why the UNC or Dr. Gopi Singh, but why Trinidad and Tobago. This country has fallen prey to the anti-vaccine movement. And I want to condemn this statement and ask the UNC and Dr. Tim Gopi Singh to produce the evidence of this raging controversy.
Minister. Yeah, Senator Mark, please. Minister, thank you. Senator Richards, any?
Yes,
further
thank you, Madam
question?
President. Minister, I don't know if you have the information, but would you be able to say if this flu season's virus is any more virulent than any other season that we've seen before?
Minister.
We have to understand that the vaccine for any flu season, which starts to run from October or November of any year, is formulated from January of that year. So what the scientists do, they try to predict what the flu virus would look like 10 months down the line. If they get it wrong, you are going to have a problem because the vaccine would not be effective. Flu vaccine effectiveness over the years, based on what I have just said, ranges from a low of 10% to a high of 90%, and it varies from year to year. So it may not be that the flu virus this year is more virulent. It could be that the estimation of what the virus looked like made back in January of this year for delivery of the vaccines in October, November of this year, based on what they guess. Because when you go into the CDC website, you actually see the word guesswork. Guesswork. Because you are predicting what the flu virus would look like 10 months into the future. And that is the problem with the influenza virus. Having said that, there is still this strong anti-vaccine movement which discourages vulnerable groups like pregnant women. The Hansard I just read out should be condemned. The UNC should be asked to produce the evidence of this raging controversy. Right? There was no raging controversy when they were not collecting data. But there's a raging controversy. Produce the evidence of this raging controversy, because there is none. And that one statement last week, Wednesday, pushed back Trinidad and Tobago years. Because I now have to work overtime to convince the population that what was said in the parliament last week is totally false, baseless, and was a reckless statement. Thank you, Madam President.
Madam President. Senator Richards.
Thank you, Minister. And with the information you just gave, would you have feedback from the patients who have accessed the vaccine about its efficacy, given the guesswork that you would have indicated sometimes goes into the prediction of what the virus may look like, in terms of their feedback? Because my understanding is that people are having second and third rounds of this, and it's not as effective as they would have liked.
I want to thank the member for that question. The influenza vaccine, and I will say it again and again and again, and I thank you, does not protect you from the common cold. You will take the influenza vaccine to vaccinate you against the influenza virus, which is distinct from the virus that causes the common cold. So you will get the common cold, as I did, even if you get the vaccine. So we have to understand that, and it's a message we have to repeat year after year after year. The other thing you have to understand, when you get the vaccine, it takes 2 weeks for the antibodies in the body to develop to protect you. So you could get the vaccination, and within that 2-week period, you can still get the influenza for which you are supposed to be protected. So your question is spot on, and I welcome the opportunity through this medium to talk to the public that the influenza vaccine, one, does not protect you against the common cold, which is not fatal. It protects you against the influenza virus, which is fatal. And two, the immunity takes about 2 weeks after the administration of the vaccine for the immunity to build up. In that 2-week period, you can still be subject to getting the influenza virus. Thank you very much, Senator Richards.
Yeah. Senator Mark?
Yeah. Can I ask the Honorable Minister, given the fact that the government has ordered 100,000 of these vaccines, and there are hundreds of thousands of adults in the population, can the minister indicate whether it is the intention of the government to step up on the ordering of more vaccines so that adults in the population who contract this particular virus can have access, easy access to the said vaccine, Madam President?
Minister?
Thank you. That's an excellent question. WHO protocol for influenza is that you do not vaccinate your entire population. Nowhere in the world does that happen. You vaccinate vulnerable populations. That is, the elderly over 65, especially if you have metabolic diseases like diabetes, obesity, hypertension. That is one vulnerable group. Vulnerable group number 2, pregnant women. Vulnerable group number 3, children between the ages of 6 months to 5 years. Vulnerable group number 4, healthcare workers. And vulnerable group number 5, those who are on immunosuppressant drugs or those with respiratory conditions like asthma. You don't, nowhere in the world, and we follow WHO guidelines. In the case of Trinidad and Tobago, you don't vaccinate 1.3 million people because the average adult between the ages of, let's say, and teenagers and adults, 20s, 30s, 40s, the influenza virus does not seriously adversely affect them. It is the vulnerable groups whose immune systems are compromised by diabetes, by obesity, by hypertension, and a vulnerable group whose immune system is not fully developed, children. Vulnerable group, pregnancy, because in pregnancy your immune system is compromised. Healthcare workers, regardless of age, because they are on the front line, and they are being exposed every single day. And asthmatics and those with respiratory disease, because the first organ of the body to be colonized by the influenza virus is your lungs. So those with lung impairment, asthma, COPD, recurrent bronchitis, they need to be vaccinated. Nowhere in the world do you vaccinate your entire population. So the 100,000 doses is enough. And to directly answer your question, yes, we have in fact ordered an extra 60,000. Of that 60,000, a batch of 14,000 will be here early in the new year. Thank you very much again, Madam President.
Senator Dylan Remy.
Minister, is there enough of the Tamiflu available?
Lovely question again, excellent question. Yes, the government of Trinidad and Tobago and all governments keep a strategic stockpile of a drug like Tamiflu. Tamiflu for the population is a drug that is used to target the H1N1 virus, especially the N part of it. So yes, we have a strategic stockpile of Tamiflu. So between the vaccines and Tamiflu, but the crucial thing is that, as you know, doctor, for Tamiflu to work, the patient must come early in the influenza cycle to be treated within the first 48 hours. As you know, as a medical doctor, after the first 48 hours, the efficacy of Tamiflu declines precipitously. And what we are noticing is that people are waiting too long to go to their physicians, their health centers. 50% of the deaths have occurred in that population, the elderly population, that waited too long to seek medical attention. So yes, there is enough stock of Tamiflu. And two, I urge the population, if you get the flu or influenza or any type of runny nose and so on, get treated so your clinician can make a distinction as to whether you have the common cold or influenza, which needs 2 different lines of treatment. Thank you again, Madam President.
Anything else? Yes, Senator Mark, you wanted to ask something? Yes?
Yeah, I just would like to ask the Honorable Minister, in light of the vulnerable groupings that he mentioned, can you explain why a number of adults over 25 into 45 have expired, have died as a result of the influenza virus. If, for instance, the adult population is not so exposed as the vulnerable groups.
Madam President, I have no, and this is where the discussion on this gets politically unproductive. Show me the evidence. Show me the evidence of what you are saying. There's a distinction between the influenza virus, which is fatal, and the common cold, which if you don't treat it, could also cause problems. Show me the evidence, and I will answer your question. But unfortunately, there is a lot of misunderstanding and mischief, which is creating undue panic. Show me the evidence, and I will respond. The same way I'm asking, show me the evidence where Dr. Gopi Singh said there is a raging controversy about the use of vaccines in the pregnant population and the pediatric population. Show me the evidence. And I want to refer people to a Facebook page by Dr. Shireen Kalu, where she links that to her article last year, proposing, advocating, encouraging women, pregnant women, to get the influenza vaccine. Another eminent gynecologist obstetrician, but another one in the parliament tarnishes the reputation of Trinidad and Tobago. Thank you, Madam President.
Next question, Senator Dinarine.
Thank you, Madam President. Question number 58 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, the country's available balances as at October 23, 2019 in TT dollars are as follows. Under the Development Loans Act, Chapter 7104, $3.2 billion. Under the External Loans Act, Chapter 7105, $13.1 billion. Under the Treasury Bills Act, Chapter 7140, $12.4 billion. Under the Treasury Notes Act, Chapter 7139, $12.9 billion. Under the Guarantee of Loans Companies Act, Chapter 7182, $24.8 billion. The value of the central bank's outstanding debt as at October 31st, 2019 was $103.5 billion. The total interest paid on loans by the central government in fiscal 2019 was TT $3.5 billion. In the month of October 2019, the interest paid by the central government totaled TT $316.7 million. Thank you, Madam President.
Senator Dinarine.
Thank you, Madam President. Can the Honourable Minister indicate through you, Madam President, whether debt sustainability analysis are being conducted at the Ministry of Finance to ensure that the debt to GDP ratio does not exceed the 65% ceiling established by the Minister of Finance during the budget 2020?
Minister.
Madam President, the Minister of Finance and his staff keep a keen eye on the balance to ensure that it doesn't cross that threshold.
Yeah. Senator Dinarine.
Thank you, Madam President. Could the Honourable Minister in the Ministry of Finance, through you, Madam President, indicate or enlighten us on some aspects of the debt reduction strategy that is using to contain the debt under these various acts?
Question doesn't arise. Next question, any? Yeah? Okay.
Motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, having regard to the second interim report of the Special Select Committee on the Evidence Amendment Bill 2019, I beg to move that the committee be granted an extension to February 29, 2020 to complete its work and submit a final report. I thank you.
Honourable Senators, the question is that the Special Select Committee appointed to consider and report on the Evidence Amendment Bill 2019 in the 5th Session 11th Parliament be granted an extension to February the 29th, 2020 to complete its work and submit a final report. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Acting Leader of Government Business.
Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 in the 5th Session, 11th Parliament, I beg to move that the committee be granted an extension to May 27, 2020 to complete its work and submit its final report. I thank you.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 in the 5th Session, 11th Parliament be granted an extension to May the 27th, 2020 to complete its work and submit a final report. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam Speaker. Thank you, Madam President. I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Madam President, I wish to express, first of all, my sincere gratitude to the honourable members of this House for allowing themselves to be convened under command of the order paper on such short notice. Albeit that we had given intention of this some time ago. And I wish to thank the Clerk of the Senate for circulating the marked up amendments to the Act as proposed to be amended by this bill, as well as the bill. The first question which jumps out at us is why so quickly? Why this bill? We then move into what is this about? What do we hope to achieve? And then we ought to move into the prospects of reform for the benefit of our citizens of Trinidad and Tobago. We make laws under the Constitution for the peace, order, and good governance of our society. So says Section 53 of the Constitution. Preliminary inquiries, which are the system of pre-trial testing of matters against an accused, have been in existence for a very long time. Madam President, we inherited these laws of preliminary inquiries. They stand as part of the laws of Trinidad and Tobago pursuant to Act of Parliament, born in 1917. We are now nearly 103 years away from that. Chapter 1201 of the laws of the Republic of Trinidad and Tobago embody the law called the Indictable Offences Preliminary Inquiry Act. It is Act number 12 of 1917. That piece of law allows effectively the continuation of preliminary inquiries as we inherited it. Born in 1555 in the Marion Statutes, 1836 in the Prisoners' Councils Act, 1848 in the Indictable Offences Act, reincarnated in the 1917 Act as Chapter 1201, we brought into existence and we carried forward effectively a law which allows two things to be done. Firstly, we make an accused aware of the case that he has to meet, as well as we give him, quite simply, an opportunity to probe and counter it. This system of preliminary inquiries is effectively, for those who are not schooled in the law, it's really quite simple. It is intended to allow the magistrate before whom an accused is brought on a serious charge called an indictable offense, as opposed to a summary offense, which is viewed in law to be something which is less serious. I think that that's now quite debatable because the consequences applied to summary offenses under financial institutions, for instance, are very serious, up to $500,000, $1 million, etc. But a magistrate has the power to hear and determine summary matters. When an indictable offense is brought forward, an accused is brought before the magistrate, and the system of preliminary inquiry starts. That system effectively allows the case to be presented. It allows an opportunity for the accused, before the accused brings evidence, if he or she so elects, to put forward a no-case submission, to say that, look, this thing just does not meet the muster. That is set out in Section 23(1) and 2 of Act number of Chapter 1201, which says that if you don't meet a prima facie case, that you can have a discharge. It allows the Director of Public Prosecutions under the Constitution and under the law, the Preliminary Inquiries Law, to have a second bite at the cherry. The DPP may effectively say, look, I don't agree that there ought to have been a discharge. In exercise of the constitutional power in Section 90 of the Constitution, the DPP can come and issue a voluntary indictment, can in fact proceed towards the court and take you to the route of the assizes, which is before the High Court. That's set out in Section 23(8) of the existing law. But this law of preliminary inquiries has witnessed Trinidad and Tobago statistically, as a matter of fact, watching a system effectively labor, causing justice to be a large question mark. We have preliminary inquiries, roughly 26,000 of them every year, 26,000 of them every year. We have preliminary inquiries that are as old as 20 years in the system. 20 years in the system. 20 years of asking a magistrate's court to consider whether someone ought to be put on trial at the High Court. In this situation, there's a basket of offenses: murder, rape, grievous assault. We have complex fraud. We have a number of indictable matters ranging in seriousness and severity, from financial crimes to severe blood crimes, where the accused, the victim, the witness, the judge, the prosecutor are all invited to participate in a ritual of attending at court for matter to be adjourned or not proceed for up to 20 years. We have a system where people are incarcerated in remand condition, where they may have been allowed the privilege of bail but can't access it, or where they're denied bail entirely because it's a non-bailable offense. And they sit in remand conditions for up to 20 years. Statistically, we have demonstrated that it costs the taxpayers of this country approximately anywhere between $15,000 to $20,000 per month per prisoner in remand condition. And if you do the math and you take one prisoner across 20 years at $25,000, Madam Speaker, Madam President, the injustice to the taxpayer is equal to the injustice to the accused who wants his name cleared, to the victim who has grown up. Someone, for instance, as a child, raped as a child, then entering the court, as we see in our newspapers, as a grown adult with children of his or her own. This is our situation. This is our country. We ask people for an opportunity to improve the criminal justice system. Why? We say that justice delayed is justice denied. We ask the Trinidad and Tobago population and the world at large to say, let us make sure that if you do the crime, you do the time. Let us make sure that if you're an accused who's innocently charged, that you have a quick trial, unless you labor under that yoke of an allegation of being a brutal member of your society when in fact you're innocent. There are competing rights in the dance. Our country has, for many years, sought to alleviate the inadequacies, ameliorate the inadequacies in the criminal justice system in preliminary inquiries. We introduced paper committals, we introduced a number of measures, but in effect, and put quite simply, the prospect of cross-examining witnesses in a preliminary inquiry effectively have put our system into difficulty. That's one aspect. It's true, we didn't have enough rules-based organization. It's true that there weren't enough judicial officers. It's true that there were just too many cases in the system. And what we did is not to hang our hat on merely abolishing preliminary inquiries, but instead we did an all-of-system approach. We increased legislatively the number of judges from 36 to 64 in the High Court. In the Court of Appeal, from 12 to 15. We introduced in 2016 the criminal proceedings rules. We created in 2016 the Family and Children Division. The Children Division deals with criminal matters for children. We introduced the Criminal Division itself in 2018, Act number 12 of 2018. We brought the Motor Vehicle and Road Traffic Amendments to remove before the magistrate who considers, the magistracy considers 146,000 cases per year, 104,000 of those are motor vehicle and road traffic offenses. We said, let's take those into the merit system. I'm pleased to tell you, all things being equal, on January 22nd, 2020, that system will go live. 104,000 cases are removed. We brought forward decriminalization of cannabis, 8,500 cases per year. I'm pleased to tell you that I'm taking a note to Cabinet on Thursday to ask for the proclamation of that law, and the Cabinet will consider that. 8,500 cases fall out of that matrix. 146 minus 104 minus 8,500 minus 26,000 cases, if we abolish preliminary inquiries, means that we leave 43 magistrates under rules-based environment with an increase in capacity, with technology in the courts to consider roughly 8,500 cases. That's what you call birthing common sense. Now, obviously the argument will prevail, well, all that you're really doing with the 26,000 cases per year is you're shifting them to the High Court. But the simple point is, whilst you are putting them to the High Court, which is why we increased the number of judges, put in the rules of court, and by next year we'll have birthed in total 100 court rooms for criminal matters. Let me repeat that. 100 courtrooms for criminal matters, taking the number of masters to hear case management from 2 to 26 by the end of next year, by the end of this year into the early part of next year. Whilst we do that, we're at least removing 10 to 20 years of pre-trial work. So let's get to the bill. We have the preliminary inquiries abolition proposed by the Parent Act. The Parent Act came into existence. It's Act number 12, it's Act which was birthed in 2011. That law was assented to December 16th, 2011. That Administration of Justice Preliminary Inquiries Act is the law that we as a parliament, then the UNC government, the PNM with support, birthed that law. It was assented to. It was not proclaimed for quite some time because there was a direct undertaking given by Mr. Volney, who served as Minister of Justice, that there would be no proclamation of that law until there were criminal proceedings rules, until there were masters of the court and more courtrooms. We know quite simply that Section 34 was proclaimed. We then went into a frenzy as a country to cause the repeal of Section 34, and that law simply lay there. We saw in 2014, Senator Vera and I were both in the parliament then, the 10th Republican Parliament, we saw the birth of the committal proceedings route. Abandoning the St. Lucia model, which is the 2011 law, which is our law, we went to the Antiguan model. In the 2011 model, we proposed that masters of court would effectively consider initial hearings for case management, sufficiency hearings, decide if you're going to have an indictable matter, send that to the High Court. If it's to be tried summarily, take it to the Magistrates' Court. In the Antiguan model in 2014, we went for the masters being replaced by the magistrates. That law was assented to. That law was then abandoned. Enter the PNM government. We felt it quite simple to simply take the DPP under his constitutional power to decide if it's indictable or summary. Why? He has the constitutional authority under Section 90. This Parliament did not feel that that was best done. We passed it in the House, but we recognized reservations in the Senate. As a result of that, as Attorney General, I went back to the drawing board, did widespread consultation, and I'd wish to thank Mrs. Pamela Elder, SC in particular, for the commentary that she offered, including the Law Association, including the DPP's office, including the judiciary, wide range of stakeholders. We took what we had birthed in the bill passed in the House of Representatives. We came and we added that into the first batch of amendments we did for the Administration of Justice 2011 law. In that first batch of amendments, we birthed that law, the amendments. We assented to that on February 13th, 2019. In fact, that first round of amendments was Act number 3 of 2019. That became Act number 3. It's not proclaimed yet. This law is not proclaimed yet. All that has been proclaimed thanks to the UNC's round of proclamation is the short title of the bill, the interpretation section, and Section 34. Section 34 was repealed. We brought these amendments, taking what we had brought as needed amendments thanks to the wide-scale consultations, brought it into the bill number 1. Bill number 2 came about because we asked the sector, the judiciary, the DPP, the Law Association, a number of players. We said, look, we want to proclaim this law. We have the criminal proceedings rules. We have masters. We're working on courts. We birthed several of them. Let's see if there are any bugs inside of here. We did a round of consultations, and we were met with amendments which were necessary. We had not thought out the process flow properly enough. The process flow included, look, if you've got a summary charge and an indictable charge as one person, how do you treat both? How do you split? What happens if you have multiple accused? What happens if documents are in electronic form? We went through a round of consultations. We tidied that up. We came with Bill number 2. Bill number 2 was assented to in June 2019, and we birthed Act number 11 of 2019. Enter this bill. Madam President, what time is full time for me?
You finish at 21 minutes past 11.
Thank you, Madam President. Enter Bill number 3, the bill before us today. Madam President, in the course of operationalization, because I'd like to tell you, every law that we have passed will be operationalized by the early part of next year. The vast majority of the laws that we have passed are already in operation. Trial by judge only, plea bargaining, children division, criminal division, anti-terrorism, income tax amendments. Motor vehicle and road traffic will come in on January 22nd, 2020. The vast majority of laws that we have passed are operationalized because we went about it this way. It's not good enough to pass law alone. You need plant and machinery, you need people, and you need processes in addition to the law. Effectively, and put quite simply, we've hired hundreds of people into the court system. Manage the DPP's growth, new offices, new procedures, computerization, information technology applied together with the law. In coming to consider the proclamation of this law, we sat with the judiciary, judges of appeal, judges of the High Court, masters of the High Court, registrars, the IT team in the judiciary, and the magistracy as well. We went through a dedicated exercise over several months of process mapping the flow of cases, case examples, material positions. After that, we went to the Office of the Director of Public Prosecutions, and I wish to pay a public compliment to the DPP himself, Mr. Roger Gaspard, Senior Counsel, who sat with me as Attorney General and our team, and with his Queen's Counsel, Mr. Edward Jenkins, went through the bill in the same process flow. We sat on many occasions. We went through this law clause by clause, comment by comment, judiciary's perspective, etc. In October, we wrote to the Law Association. We wrote to the Criminal Bar Association. I saw the notices go out, if I can recall correctly. We have not received commentary from the lawyers effectively, but it's not to say we didn't ask and also remind and also call and also plead, but you can only take a horse to water. Coming before this Parliament now, having had the full process flow go forward, we've come forward with a few amendments and a few innovations. We recognized in the House of Representatives that there was a need for a certain layer of protection to be added further to one of the novelties and progressive points that we brought forward, and I'll come to that in a moment. But effectively, we have come forward in this bill with 24 clauses, including the short title, including the interpretation. In this, we effectively seek to, first of all, at clause 3, we look to extend the definition of arrest warrant. Why? The law as drafted, as amended twice, contemplated that you'd only find yourself before the court under the provisions of that act. That's not true. You can be arrested under the Proceeds of Crime Act, Anti-Gang Act, a number of pieces of law. So we had to amend the definition of arrest warrant to include any other written law. We then went on, Madam President, very important amendment, to extend the definition of documentary exhibits. Why? Particularly in complex fraud matters, the issue of documentary exhibits comes about. Right now, we are looking at certain matters that are imminent. We're looking at millions of documents. Let me repeat this. Millions of documents in complex fraud matters. If we go about this the old hand way of tendering and marking every single document with the initials and the letters, can you imagine tendering and marking 4 million documents? It's insane. It will effectively erode justice. We look to the United Kingdom, we look to other jurisdictions, we saw the admissibility of evidence, particularly for complex fraud matters, and we allow that by having the digital device, by allowing the use of technology, and very importantly, and it's in the bill, having the master certify the list of documents so that there's precision in the use of documents. Obviously, it's still open to defense and prosecution counsel to, in the admissibility cycle, to also then take their arguments to weight and relevance, and then look to see whether, in fact, the evidence ought to be not considered by the court or disregarded or, in fact, struck out. We have, Madam President, the need to have a definition for the minister. We put the minister as the Minister for Criminal Justice. Why? As per my undertaking to the Parliament, this Senate, in looking at Section 24 of this law. Section 24 of this law says, if the DPP does not indict you within 1 year after the sufficiency hearing, you can apply for a discharge on the ground of delay. We specifically gave the undertaking that we would amend the 6th schedule. The 6th schedule is the schedule of matters that says you cannot be discharged on the ground of delay pursuant to Section 24 for the matters listed. There was no reference to complex fraud matters, to offenses involving money laundering, terrorism, gang-related activities, cybercrime, misbehavior in public office, and offenses trafficking in persons. And therefore, in October of this year, on the 4th of October this year, as Attorney General, I amended the 6th schedule. That's now part of the law. So there's no ground of discharge pursuant to Section 24 for alleged delay, albeit that that is something that is arguable. It's important to say what you will not have an easy discharge for. That is, of course, rooted right back to the Section 34 arguments and why it ought not to have been proclaimed. We call the definition of summons. It's really just a merely drafting definition cleanup. In Clause 4, we seek to treat with the application of the Act. Law is generally prospective in nature. We allow for matters prior to the proclamation of this Act to be brought under or converted to the new system in 2 ways and under certain circumstances. The prosecutor can elect, that's option 1. The defense attorney can elect, that's option number 2. Conditions, you can't choose the charges, you must go with all. You can't choose the defendants, you must go with all. We have removed the need for agreement between defense and prosecution because they will agree to disagree. That's just quite simply the method in which you go. We anchor our constitutionality in the Hilroy-Humphreys case, which is a case in the Privy Council, which effectively says there's no right to a preliminary inquiry. It's just a method of trial, and there's due process there, so you don't have any constitutional infringement by effectively abolishing preliminary inquiries. That's been settled for many, many, many years right now. We have, in Clause 5, done some surgery. We've added in an aircraft because that was inadvertently omitted it is in Chapter 1201, the existing law. It should have been returned. Clause 5 also provides for a constable executing a search warrant to be accompanied by other persons. Why? You are going to need experts on the scene. The police work with the experts. They do that as a matter of fact. We want to make it abundantly clear, particularly when you're looking at information technology access issues. You're looking at DNA samples being taken by experts, etc. We have borrowed from Section 16 of the PACE Act, that's the Police and Criminal Evidence Act 1984 of the United Kingdom. Madam Speaker, Madam President, in Clause 5(1)(a), we allow something which is a novelty and which we amended in the House. We allow for a master, not a magistrate, a master to issue search warrants that authorize search of multiple premises or any premises occupied or controlled by a person. Section 8(3) of PACE, the English law which I just referred you to, has this provision. Many other Commonwealth jurisdictions have this provision. In Trinidad and Tobago, there can be a frustration of the law, which was long since abandoned by the United Kingdom, abandoned in 1984 as a matter of fact, where our police have been relying upon hot pursuit. That is the fact that reasonable suspicion they may enter premises, etc. Or worse yet, having to go back to the magistrate every time. It is important in the conduct of an exercise that you have the ability for the police officer who's authorized under warrant to have the ability to access premises which at the point of obtaining the warrant may not be known to be in fact owned by someone. You arrive at the premises and then you realize, well, it's in fact warehouse X owned by this person or warehouse Y owned by that person. In the House, the submission came that we ought to not use what the United Kingdom had, which is allowing for unlimited number of times for searching. Accordingly, we deleted those provisions from the bill, which you would have seen in the earlier version, which we passed around. And very importantly, we added in some very structured and important amendments to the conditionalities for the grant of the warrant. We are proposing, and it's in this bill as it comes from the House, that the master may issue that search warrant in the circumstances set out through paragraphs A to D. It's not practicable to communicate with any person entitled to grant entry to the premises. It's not practicable to communicate with a person entitled to grant entry to the premises, but it is not practicable to communicate with any person entitled to grant the access. Entry to the premises will not be granted unless a warrant is produced, or the purpose of a search may be frustrated or seriously prejudiced unless a constable arriving at the premises can secure immediate entry into the premises. Very important, the issuance of search warrants, which is the existing law. The existing law, Chapter 1201, says a magistrate can issue a search warrant. There are no conditionalities for the search warrant. In the existing law, there are no conditionalities for the search warrant. In the existing law, there's no time frame for the existing warrant. What we have done here now is to include in the law for the first time, in particular in this multiple searches position, that the master, not a magistrate, a master sitting in the High Court, can actually put terms and conditions into the warrant. The police, as a rule of thumb, have warrants issued, but they generally go back for fresh warrants after 1 month. But there is nothing in the law that says that. We are allowing this feature for the first time to be introduced by this bill, and this is a material improvement to the law in my respectful view, Madam President. Madam President, we're allowing for further safeguards in the new subsection 5(2)(a), in clause 5(2)(a). In that, we're actually providing for the mandatory proof that you're a policeman, the production of your identification, the fact that you must give a search warrant, the copy of the search warrant to the person whom you are searching. Why? Too many cases come before the court where people allege a search warrant was flashed, a copy was never given to me, I didn't see it, I was laboring under malicious prosecution. And in these circumstances, we propose a material improvement to the law. Let why you are there be known specifically. Give the people a copy of the search warrant. There must be no if, and, or but about that scenario. Madam Speaker, clause 5(6) is a very important provision. Clause 5.6 allows for photographs, digital recordings, other images seized to be admissible as sufficient evidence. Why? Right now, the process is under the law that exists right now, and you'll see it in fact. If a container of alcohol is seized, they bring the container to the court. If a boat or a pirogue is seized, sometimes you'll see it outside the court. The magistrate must convene the court at the location to identify the thing seized. Bags full of marijuana must be brought forward. Guns must be brought forward. We allow for the photographic evidence to be used. Obviously, there's certification of experts to say a thing is a thing, the admissibility of the evidence, the marking and tendering of the exhibits, the use of IT, of digital recordings and photographs, is in every other jurisdiction, and we, of course, bring it to ours. Madam Speaker, Madam President, it obviously allows for early restoration. There is no reason why a third party whose item is seized, somebody stole a car from John Brown. The car is evidence in the matter. The police then say to you, now we have to hold on to this evidence because the trial is in 10 years' time. Why? Why do you have to go through the process? There is a process of restoration, but we ought to make it easier. Let's take the photograph. It's long past the time where you ought to see graveyards of equipment being sought out there, and a thriving cannibalistic trade of selling parts on the stolen car market, Madam President. That's just wrong, and we ought to move away from that. Clause 6 allows, it repeals Section 6.1 of the Act. It enables a master to summons, whether a complaint is on oath or the oath is there. It allows for the arrest warrant to be issued where the complaint is on oath. On oath, we have done the surgery to the language there. It was not properly or clearly stated, and therefore we've sought to improve the language there. Clause 6.1b, we are allowing a complaint would be required to be in the new Form 4, and we've inserted that into Schedule 1. Effectively, we're trying to case manage. We're trying to standardize the approach to avoid the various iterations that complicate whether you've done it right or wrong. Madam Speaker, Clause 6, of course, allows us to go into a move away from the concept of arraignment and instead to the reference to trial. This is where the DPP is allowed to file an indictment in respect of a co-accused, where the accused has been indicted and the co-accused is arrested. We had provided that that must be done before arraignment. We're now going to trial because the judiciary pointed out to us and the DPP agreed that there could be a significant time period between arraignment and trial, and they preferred the concept of trial. Madam Speaker, Madam President, Clause 7 deals with proof of service. The law as currently crafted means the policeman has to come to court. In the High Court, you can prove service by an affidavit of service. So we've gone with the affidavit of service basis, borrowing from the civil law concepts. Of course, it is open to the court to summons the policeman who served to the court, but there's no need to occupy police time on a mere formality of service when it can in fact be dealt with under oath before the court, Madam President. Madam President, 8.8, Clause 8.8, provides that where a person is charged with an indictable offense, he should be brought, not arrested, because it's in fact the charge that we're in fact looking for. Of course, the current law of habeas corpus, etc., still prevails. You have your rights before the court, and that is something which I think we ought to not have too much difficulty with. In the new subsection 7A, we're requiring, there's no provision currently for an initiation document before the court where a person is arrested and charged upon committing an offense where neither a summons or warrant was used. That's an anomaly, and we needed to solve it by the proposed amendments here. Madam Speaker, Madam President, forgive me, I sit in both places, no offense intended. Madam President, in Clause 9, we're deleting the reference to session. The judiciary tells us quite simply it's just not used. Under the case management cycle, the registrar will have the ability in the case management and in the scheduling aspects to just simply give the date. It's synonymous with the criminal proceedings rules. Madam President, Clause 10. Clause 10 empowers the registrar to have place in this law. Why? We had included the magistracy registrar. It is axiomatic that we ought to include the registrar of the Supreme Court. That harmonizes us with Act number 12 of 2018. That is the criminal division and road traffic division that we have created. where we just simply allow the registrar this position. I want to remind that the clerk of the peace had a power before, under the existing law. Before we amended the law, the clerk of the peace was not even a lawyer. We are now equipped in our magistracy where lawyers function as registrars of the magistracy. That's a first in time, never existed before, all in situ, all in operation. Clause 11, Madam President, here's where we allow for the time to be adjusted. We had provided in the statute, in the act as we amended, not yet proclaimed, that there were fixed time frames for movement. In looking to operationalize this law in the month of January, let me repeat this, in looking to abolish preliminary inquiries in the month of January 2020, the need for the master to consider the adjustment of timelines in keeping with rules, in keeping with the common sense of the provision for both prosecution and defense came about. It was a recommendation from the judiciary and also from the DPP to say, look, if we're going to start this, we need to make sure we can get the thing working. Let's work our way into success. Let me stick a pin. For those who are either too young or who are not practitioners, the civil proceedings rules were met with riot. There was bitter complaint all over Trinidad and Tobago. In fact, there were some very strong advocates against it. There was mayhem. The civil proceedings rules changed practice in Trinidad and Tobago. We reduced the backlog from 17 years to 1 by paper-based management, application of rules. What was lacking in common sense is why nobody did it for the criminal side. It just made no sense that no one saw it fit to amend the processes, the people, and provide the plant and machinery. And that's why I constantly echo my refrain, plant and machinery, people, processes, and law. And we are already seeing, it's not perfect, we are improving. We went through the tragedies of the decision of Mr. Justice of Appeal Jamada, and I mean this intellectually because the Privy Council reversed that decision in the Trincan case where we had implied sanctions dealing. We went through all of those things. But the civil proceedings have improved to such a state where we really ought to get our criminal division up and running in this fashion. Justice ought not to be delayed. Madam President, let's look to Clause 11.6. We're permitting the filing of electronic documents. Let's stick a pin here. Madam President, thanks to Chief Justice Archie, who ventured to Nigeria, who obtained software for free from the government of Nigeria, who then had the government of Spain improve the software for free, gifting all of the technology to the government of Trinidad and Tobago. We have introduced TT Jim, J-I-M. That is a replacement of TT GEMS, G-E-M-S. That has allowed the magistracy to be computerized for the first time. There will be FTR, that's recording technology in the courtrooms. In this new courthouse, because this is what Parliament Tower D's building is going to be, and in the Hall of Justice, we will have the audio and visual recording of trials. Just like Parliament Channel, just like the Privy Council, and on the TT-JIM platform, we allow for electronic filing. At the Office of the Attorney General, we have taken as the facilitator of the DPP's division, the Judiciary's division, and now borrowing into the TTPS, we have taken that technology and applied it to all three. So the DPP's office, the TTPS, and also soon the public defenders as we open that up in the cusp of the new year, all of these will be working on the same electronic platform, which makes the filing of documents easy, the service of documents easy. Plant and machinery, people, processes, and law working in tandem. Madam President, Clause 12 amends Section 12 of the Act. There was an anomaly where we had disapplied the maximum aspects on a summary trial for kidnapping. We believe that that is a fetter of the judiciary's discretion. We have stepped aside from that. We're borrowing from the Barry Francis and umpteen other decisions. Any which way you want to slice it or dice it, we will leave that to the judiciary Madam President. Clause 13, I think Senator Hosein and Senator Chote will be very happy with this one. Albeit on the first iterations of the law, we were encouraged by all of the stakeholders at the judiciary and at the DPP's office to just simply go with 23(2) of the existing law, sufficient evidence. The DPP asked us to go back to the utilization of prima facie. Even though in the 2014 and 2011 laws passed by the last government, we had iterations on the one hand using prima facie and on the other hand just using sufficient evidence, even though other jurisdictions use sufficient evidence, even section 23(2) of the existing law says sufficient evidence. The DPP asked us to re-include the standard of proof as prima facie evidence. Why? It's higher than the standard of proof of balance on balance of probabilities. It is always intended that prima facie would be there. Out of an abundance of caution, the recommendations came to go back to prima facie standard, so you'll see it throughout the bill. Throughout the bill, we have added in that you must have a prima facie case, and that is now settled law as to what prima facie means. And there are people by far more qualified to speak to that, such as Senator Chote, in the course of this debate than I am. Madam President, we go in clause 13.
Attorney General, you have 5 more minutes.
Much obliged. We go in clause 13 to empower a master to determine when a sufficiency hearing would not be held in open court. We've done that to harmonize judicial discretion alongside with our special select committee on evidence. We wish to birth anonymous witness anonymity. We wish to birth protection of witnesses. Whether we will have that as a matter of reality depends upon something which I ought not to speak to in detail yet, but we're waiting on that to come forward. We want to harmonize the protection of witnesses by allowing the court to consider when it is appropriate to be in open court or not in open court. Clause 14 amends section 20 of the Act. We are allowing for the incorporation of section 22(4) of PACE, that is the English law. We're including new subsections 5 and 6 to facilitate production and marking of electronic copies of exhibits, tendering of photographs, etc., as I referred to a little bit earlier. That just simply improves the complex fraud cases management. We, of course, also rely upon the case of R.V. Uxbridge Justices, 1987-85 criminal appeals reported at page 367. In other words, and translated into non-lawyer speak, there is ample precedent for this in existence in the Commonwealth, and we propose that we use digital evidence and marking, etc., allowing for the ease of trial management. Madam President, that is included with the safeguard in subclause 7, where we ask the master to keep the list of exhibits and for that to be certified. Madam President, you'll see in the further subsection there, we've gone back to the prima facie standard throughout the bill. Clause 15 amends section 21 of the Act, and I know Senator Thompson-Ayi would be interested in this one. We have taken the age down from 14 to 10 years so that we harmonize it with section 98(1) of the Children's Act. So we're keeping the law in pari materia. We are just making sure that this law says exactly what the Children's Act says with respect to the use of safeguards and submissions, unsworn statements as it relates to children. Clause 16, again, repeats the prima facie standard. Clause 16, we are allowing for a redrafting simply for the sake of clarity, where the DPP makes the salvo to bring the person back before the court, where the DPP considers, as the existing law in section 23 of chapter 1201 contemplates, where the DPP has that power. Clause 17 amends section 25 of the Act. Again, we are reiterating the prima facie case standard. Clause 18 amends section 26B of the Act. Madam President, we're allowing for additional relevant evidence as opposed to additional evidence of a material nature to be given at fresh evidence. Clause 19 amends section 26C of the Act. We're replacing the magistrate throughout with court. Why? Under the criminal division allows the merger of jurisdictions. Magistrate, master, and judge may act in all of these circumstances, so it was inappropriate to just refer to a magistrate when a judge or a master could have done the same job under the criminal division. Madam President, we're allowing in clause 20 for the concept of original documents. Throughout the world, original documents are produced where the judge tells you bring it. Otherwise, the copies of the documents are reduced, and this is just for better case management. There are safeguards in law that exists. We're going for, in clause 21, where witness evidence is not in dispute as opposed to formal in nature. Madam President, the last one I have a few seconds to deal with is the abolition of section 14B of the Evidence Act. In the year 2000, the English experience abolished their equivalent of section 69 of PACE, reverting to the common law. We have been advised that particularly in the example of complex fraud, that computer evidence, if we rely upon the provisions of section 14B, can be very complicated. This came in a direct written submission made to the world at large by the DPP in the Special Select Committee when it was on the public hearing program. We agree with that provision, and we think that it ought to be included. Madam President, this is good law and proportionate. I look forward to these submissions, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Before I call on Senator Hosein to speak, with your permission, I'd just like to revert to the earlier item on the order paper. I am now in receipt of the instrument. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Augustus Thomas. Whereas Senator the Honorable Franklin Can is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by sections 44(1)(b) and 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Augustus Thomas, to be a member of the Senate temporarily, with effect from the 18th of December 2019, and continuing during the absence of Senator the Honorable Franklin Can by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the Office of the President St. Anne's, this 18th day of December 2019. Honourable Senators, the Senator is required to take the oath.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Senator Hosein.
Thank you very much, Madam President, and welcome back. Madam President, thank you for the opportunity to allow me to join this debate on an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, and this being Bill number 3, which is the third rounds of an amendment with respect to this particular act. Madam President, this is the third time we have come here for the year to amend this particular piece of legislation. after this particular procedure has been in existence in this country for over 100 years, in 2011, a bold step was taken by the previous government in an attempt to reform. I know the Attorney General will say it's abolishing preliminary inquiries, but it's really a reform of the preliminary inquiries rather than an abolition, because you still have that filtering or that stage in which the matters go before a master before they end up before a judge and a jury or a judge alone. And this Parent Act, Madam President, the 2011 Act, was passed and assented on the 16th of December 2011. So 2 days ago, we had the 8th-year anniversary of this particular law. And all of us in this Parliament, I'm sure, will welcome such an initiative so that we can get the criminal justice system working, so that we can start speeding up the trials, so that we can bring those who are apprehended and those who are guilty before the courts, so that they can have a trial, so that we can have quick convictions and sentences, Madam President. Because no one in Trinidad and Tobago can say that they are satisfied with the condition in which our criminal justice system finds itself in. And, Madam President, on the first set of amendments that came in November 2018, that bill was laid in the other place in 2018. And it took 3 months for that bill to get through the Parliament, and it was subsequently assented to on the 13th of February 2019. Act number 2 that amended this bill was laid on the 22nd of March 2019 and was then assented to on the 21st of June 2019. Again, took approximately 3 months for it to be passed. Now we come with this third amendment, Madam President, and we are hurrying through this particular amendment. The Attorney General indicated that he has a January deadline or a target that he wants to meet. But, Madam President, you would see that due to the mismanagement of the government's legislative agenda, we find ourselves here time after time in this Parliament just rushing through particular pieces of legislation. And, Madam President, had...
You will have your time, Minister.
Minister of Trade and Industry, please desist from any comment across the floor. Senator Mark, likewise. Senator Amin, likewise. Okay. Senator Hosein, please continue.
Thank you very much, Madam President. And, Madam President, time and time again, if it's not a deadline, it's because they have to pass a particular amendment to some law. Madam President, I understand what is happening in the Parliament, that the Parliament is going to move, but I question, Madam President, what is the urgency of this particular legislation? Last week, Saturday, we were here for some other emergency, Madam President, where all they could have found was a barber who earned $1 million so far, and you have hundreds of people every day lining up in the banks and suffering with the distress that this government has put on them.
Senator Hosein, may I caution you very early in your contribution to be relevant to this matter, okay?
Much, Madam President. And, Madam President, the point is that time and time you just keep rushing through legislation, and ultimately the people of this continue to suffer. But this government will continue to push legislation and hurry us in this Parliament, but the people will push them out of office very soon, Madam President. And the Attorney General said that January 2020, things will happen. Talk again. There's plenty talking, Madam President. Talk. That you will have tens of thousands of cases dropping off the court, tens of thousands of cases freeing up the court so that the court will be free to now deal with only criminal matters of this nature. But I have a few questions I want to ask the Honorable Attorney General, Madam President, through you. Since the new criminal masters in this entire sufficiency hearing are going to drive this process, can the Honorable Attorney General advise this Parliament where are they going to sit? Because it cannot be by January we are going to get the 100 courtrooms that is promised. Madam President, have they sourced any additional courtrooms? Have they outfitted these courtrooms with the necessary infrastructure, Madam President? Madam President, there's currently a fight for space at the Hall of Justice and the San Fernando Supreme Court. We all know what is happening in that Supreme Court in San Fernando. You have a high court hearing civil matters. You have a high court hearing criminal matters. You have the magistrate court in the same building. You have all of the administrative offices in that same building. And then you're coming to this parliament to tell the people that January you're coming to abolish preliminary inquiries when you have not constructed a single new courtroom in this country. Can you tell us, did the judiciary hire any additional staff and train them in time to meet this target of January 2020? Did you increase the complement of the legal aid? Because defense counsels and their availability for criminal trials in this country is an issue. Did you increase the attorneys at the Legal Aid and Advisory Authority in order to now take this new influx of matters? What about the staffing at the DPP's office? How many new prosecutors were hired, Madam President, in order to meet this January 2020 deadline? Can you tell us how many police officers who are going to be prosecutors using this particular piece of law? How many of them were hired and trained to go to court, Madam President? The Attorney General spoke of the DPP's office getting new accommodation. The last time I drove down Richmond Street was this week. I saw that the DPP's office was still at Richmond Street. When you look at San Fernando, the DPP office is still in Independence Avenue. Where are the offices that you promised for the Director of Public Prosecutions? They are in very cramped, uncomfortable conditions, and now you are going to increase their workload and their burden. And this law will not work unless you do the work and get the necessary infrastructure and resources done, Madam President. So my question is it that you are really meeting this January deadline for some other purpose, Madam President? And that is a question that I will continue to ask, and I know my colleagues will also ask, Madam President. Now, when you look at what is happening in the judiciary, when you look at what is happening in the magistrate court, especially, Madam President, I looked at the last annual report, which would have been the 2017-2018 report, Madam President. And this is what happens in the magistrate court in this country. In criminal matters that were filed in the 14 magisterial districts, you had 118 capital matters filed. And the non-capital matters, you had 23,815 matters, Madam President. That shows the amount of matters. Now, some of those non-capital matters will be disaggregated into indictable proceedings and also summary proceedings. Now, the judiciary did not disaggregate those matters, neither did they give us the amount of preliminary inquiries that are currently before the court. We have no official statistics from the judiciary with respect to that. But, Madam President, we will appreciate that there are thousands of cases currently before the court, hundreds of cases that are part-heard, Madam President, that are currently before the court, and we have to deal with it. Madam President, we have lent this government support when they require the support. But, Madam President, there are very offensive clauses in this particular bill that we are not prepared to support unless those clauses are amended, Madam President. And the Attorney General was right when he piloted this particular bill. He said that there will be a bottleneck because you are just moving the matters up the chain, Madam President. You are taking them out from the magistrate court and you're going to send them in the assizes. Can the Attorney General advise us how many new judges have been hired to now deal with these matters in the assizes? Because you will appreciate, Madam President, when this particular bill is passed, you will find that the sufficiency hearings, based on whatever backlog that we have that we don't know about, but the new cases that may come will actually be disposed of quicker, meaning that they go up the ladder into the assizes. So can the Attorney General tell us what resources are going to be put in place with respect to dealing with the backlog that will come with respect to the proclamation and the implementation of this act? What will come? Because, Madam President, you will appreciate when you look at this particular legislation, it now includes electronic filing of documents to speed up the process. But one of the particular drivers with respect to the new procedure of the sufficiency hearing is a paper-based procedure. Because you are now getting rid of leading evidence via viva voce and you are now getting rid of the cross-examination of particular witnesses, which all of us in the Senate will appreciate is a very time-consuming procedure. Now, we tried this already, Madam President. In 2005, there was an amendment made to the existing law to allow for something called paper committals. But what happened with the paper committals is that we thought that it would have disposed of these cases very quickly, meaning that as a witness in any criminal matter, I file a sworn statement, I sign it, it's served and filed, Madam President. And then the defense counsel has an opportunity to determine whether or not he would require the witness for cross-examination. So therefore, the magistrate who is sitting can form a view whether or not the evidence before him or her is sufficient enough that it establishes a prima facie case. Now, with that particular amendment that came to the old law, which is it's a very similar process to what is taking place here, is that you had problems, Madam President, with witnesses especially and police officers in this country. Because you would have police officers coming to attend a preliminary inquiry hearing, and you would hear that they have not gotten the statement signed by the witness after 4 years. What has been put in place to prevent that from occurring now? Because as I said earlier, this is also going to be a very heavily paper-driven procedure that is going to take place. Has enough been done to identify that problem and have some solution? Because we will end up, as I said, in the same position. And, Madam President, those are some of the concerns I have with respect to the administrative part of the criminal justice system. Because we could pass all the laws that we want in this Parliament. If it's not properly implemented, then we reach nowhere. Then we would just have words written on a piece of paper, and it means nothing, Madam President, unless it can be properly implemented. The first clause I want to deal with in this particular bill, Madam President, it's Clause 5 of the bill. And Clause 5 of the bill is probably one of the most absurd and objectionable clause that I saw in this bill, Madam President, because it deals with an invasion of your constitutional rights, freedoms, and privileges, Madam President. When I read this, I thought, Madam President, that this government may have forgotten that we have something called the Constitution. So, Madam President, I would just ask you to allow me to remind them what the Constitution says and the rights that are guaranteed to persons who are subject to the criminal courts. And any individual who is a citizen of Trinidad and Tobago, Madam President. Because the Constitution says that a person has the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived of except by due process of law. The right of the individual to equality before the law and protection of the law. Madam President, a right to a fair and public hearing by an independent and impartial tribunal. Madam President, these are some of the rights that we have in this country. This Constitution is the supreme law of the land. And continuously, Madam President, we have seen a government that has shown disrespect to our supreme law of the land. Complete and total disrespect. And Madam President, my colleague said it in the other place. Is it that the intention of this government is to change a democratic state, that is Trinidad and Tobago, into a police state? With this type of offensive laws that they want to implement in this country, Madam President? Look at what happened in the previous law. When we amended this bill in February, that bill was assented to, Madam President. You would have seen that the Attorney General, there's constantly a chipping away of the protections allowed by the law in this section. Madam President, when you look at what happened in that first amendment to this particular clause, you would have seen that the Attorney General would have changed and amended the standard for the acquisition of a search warrant from reasonable grounds for believing to reasonable grounds for suspecting. there's jurisprudence and there's literature to show that the reasonable grounds for suspecting standard is actually a lower standard than that of reasonable grounds for believing that an indictable offense was committed. Madam President, that is one aspect of what happened in the first amendment to this. We come with the third amendment now, and what you have more invasive powers now. More invasive powers in this particular piece of legislation, where you now find that the police in this country, this is the power given to the police in this country, that they can be accompanied by any person to go and execute an arrest warrant. Who is this any person? The partner, the paliwal, that's who they're carrying to execute this warrant. Any person, Madam President. Last time I checked, police officers are the only persons who should be authorized by law to execute a search warrant. Why is the police going to be accompanied by any other person? This is a very wide and far-reaching provision, and this is found, Madam President, at Clause 5 of the bill. Then you go on to here and read that a new power is being given so that a search warrant could now be issued for multiple premises, and you don't even have to particularize the premises. Madam President, that is absurd in this country. That means we are giving what? The police officers are free for all in this country now? We must remember what happened in Gulfview when just last month, and I think the Attorney General was present at that meeting, where the Commissioner of Police in this country had to apologize for the execution of search warrants to the residents of Gulfview, Madam President. Madam President, I have an article here dated the 22nd of November 2019, written by Richard Khan. Gary apologizes to Gulfview. That is what it says, Madam President. The Attorney General was photographed with the Commissioner of Police there. I think he went to meet his constituents after a very long time. But, Madam President, this is what you are going to give the police powers to do now? Just last week, you brought a bill to this Parliament to say that there's problems in the police service, so we're going to increase fines for misbehavior. And this week, you're going to give them so much power? What is really happening with this government? What is happening with this government, Madam President? Madam President, then you have, it reads that a police officer can get a search warrant if it is not reasonably practical to specify in the application for the search warrant all the premises in which the person occupies or controls and which might need to be searched. Is it that we are now legislating for investigation and surveillance in this country so that the police don't need to do any work? All they need to do is just go and get a warrant and say, well, I can't list all of these persons, where they live, I don't know how much property they have, but just give them a warrant.
Imagine that.
No investigation. Yes. And the standard for acquiring a search warrant in this country is very low now. It's reasonable grounds for suspecting. Madam President, this government is continuously whittling away at the rights and privileges of the people of Trinidad and Tobago. There are so much laws in this country and so much authorities in this country. You have the Interception of Communication Act, Anti-Gang, Explain Your Wealth, all of these bills that were passed, Madam President, and you now come here to legislate that you don't know which property you're going to execute a warrant on, and you ask this Parliament to approve that. Madam President, we cannot support that, Madam President. We cannot support that. Madam President, then you have Clause 1B, Clause 5, 1B, and new 1B is being inserted, where it allows a search warrant to now be issued so that the police can go multiple times over a specific time period and execute your warrant. So if, for example, they get a warrant to execute on Senator Mark's house for 1 month, every day the police officers might be in Senator Mark's house. This is the law that they want to pass in this country, Madam President. We have seen how the police has operated. We know that there are bad police in this country. I commend the good police officers in this country. But, Madam President, we have to have the checks and balances on this institution. We cannot, as a conscionable parliament, allow particular pieces of legislation like this to be passed. This parliament is not no rubber stamp. It may be treated like one by this government, but this parliament ought not to be any rubber stamp in this country, because we will stand up for the rights and privilege of the people of this country, the ordinary man of this country, Madam President. We will protect those persons, and the Attorney General under the Constitution has to be the guardian of the public's interest. And when you bring laws like this, how can we certify and have confidence that the Attorney General is the protector of the public's interest? Madam President, do you know what happens when things like this happen, when search warrants are issued, especially on business people in this country? There's a stigma attached to these persons. They will tell you that this business stigma that they get, they will lose business, Madam President. Do you know the trauma that families suffer when police officers come heavily armed in homes? And now you're allowing this to be happening on multiple occasions, Madam President, over a particular time period. We cannot support this particular clause, Madam President. We cannot support this particular clause at all. I am of the belief, Madam President, that if the Attorney General wants to put this in the law, let him come with a constitutional majority, Madam President. Let him come with that. When I would now go on to what happens with respect to the execution of the search warrant. The Attorney General said that they put some safeguards in the law. And, Madam President, it says that when a police officer, for example, this is at page 5 of the bill, new clause 2A, it says where the occupier of any place which is to be searched is present at the time when the constable seeks to execute a search warrant. The constable shall, identify himself to the occupier, and if not in uniform, shall produce to him documentary evidence that he is a constable. B, produce the search warrant to the occupier, and C, supply the occupier with a copy of the search warrant. Now, I am glad that that is now in the law. It provides some sort of check and balance and safeguard to the persons whose homes are going to be searched. But, Madam President, what happens if the police doesn't do this? What is the sanction that the police officer faces if he does not identify himself, if he doesn't produce the search warrant, and he does not supply them with a copy of the search warrant? Because we know in this country, Madam President, that when search warrants are being executed, sometimes the person who is in the home is not shown a copy of the search warrant, or the search warrant is not even read to them, Madam President. So in this particular clause, I want to ask the Attorney General that we put some sort of sanction with respect to police officers who do not comply with this particular provision. I also would like to ask the Attorney General that on production of the search warrant, let us amend the law further to ask that the police officer now be placed or given an obligation to also read the search warrant to the present occupier or the owner of that property. Right? That is what we need to do, Madam President. Because you have to understand there are persons who may not be able to read in this country. Madam President, this is what the Attorney General brought for us in this Parliament in order to pass and for us to approve. Madam President, we in the opposition, we are not going to approve this. I can say that. Now, Madam President, when I look at Clause 6, and I want to ask the Attorney General whether or not this was an omission. At Clause 6A, where it reads, where a complaint in writing is made to a master that an indictable offense has been committed by an accused, the master may, if he is satisfied that there are reasonable grounds that an indictable offense has committed. Attorney General, I want to ask if after the words reasonable grounds, to be consistent with the other provisions of the bill, whether or not you would be placing the words reasonable grounds for believing or reasonable grounds for suspecting, because it's open there. I don't know if that was omitted, or if it was deliberate, or if it was omitted. Now, the next clause I want to deal with is with respect to Clause 11. Now, Clause 11 provides for extensions of times with respect to directions being prescribed by the particular law. And this amends Section 11 of the Act, in particular, subclause 2H, Madam President. And this provides for example, the filing of the witness statements and the exhibits that would be annexed to the witness statements. And currently, the time in which that this has to be done is 3 months from the date of the scheduling order. So the prosecution must file within 3 months of that. Now I see that an additional power is being given to the master to also extend that period, but that has to also be read alongside sub 5, which deals with that the master can only grant one extension for a period of 14 days. Also, the accused only has 28 days in order to file his witness statements afterwards when he is served with the prosecutor's witness statement. I want to ask the Attorney General whether or not we should be fair and also enlarge the time for the accused person to also file his witness statements, because it's particularly unfair that the prosecution has 3 months and now the accused is only being given 28 days, Madam President.
Must be balanced.
Madam President, I also want to deal with the clause that deals with the electronic filing of witness statements. I want to ask the Attorney General whether or not this particular provision deals with witness statements of witnesses who may be abroad, and they may have to be required to file witness statements right here in Trinidad, whether or not the registry, there's an electronic registry set up already for the filing of these particular witness statements, and also whether or not this deals with witnesses abroad. Now, I was looking at the CETAHAL, as we commonly call it, the text, Commonwealth Caribbean Criminal Practice and Procedure, and I was looking at the provision in Grenada that deals with the requirements and the stipulations with respect to written statements. And there's a list of conditions that must be satisfied in terms of that the witness statements must be signed, they must contain a certificate or a declaration that the person knows that whatever is contained in that statement is to the best of his knowledge. It must be served 2 days before, and there's no objection. So I want to know whether or not these particular prescriptions will be covered in the criminal procedure rules, or should we prescribe it in the particular law itself, Madam President, especially when it comes to electronic filing, because I don't know what conditions now that has to be satisfied if you would be required to file your witness statements in an electronic format. Now, as the Attorney General said, with respect to the standard in which the master has to satisfy himself or herself of is now including the prima facie case. I know we had a lot of tug of war with respect to this particular provision, Madam President, in the past. I even printed all of the Hansard, where myself, Senator Chote, Senator Vera would have fought for this particular inclusion. And we told the Attorney General, we advised the Attorney General that the standard is vague, that sufficient evidence alone is very vague. We don't know what it means. Therefore, you must have the settled test of what is a prima facie case. And just for the record, Madam President, the prima facie case standard is coming out from the settled case of the Queen against Galbraith, where it says that the evidence must be sufficient that a jury properly directed will convict, Madam President. And that is the test with respect to what the prima facie case is. And we had pleaded with the Attorney General that that is a requirement, because we can't just leave it up to the masters to determine what a prima facie case is, because it would be extremely vague when this law is applied, especially to the litigants and the accused persons, Madam President. Now, there's one other particular clause I want to deal with, which is the new clause 24 that was included in the other place, Madam President. And that clause 24 deals with the amendment to the Evidence Act. This is found in the schedule, Madam President. And what it does it repeals Section 14B of the Evidence Act, Chapter 702. Now, the Evidence Act, Madam President, provides for the method in which computer-generated records will be admissible in court. Now, from my learning and from consultation with other persons, we agreed, Madam President, that computer-generated records will be or will constitute hearsay evidence. Now, there are 3 exceptions to the hearsay rule. One being res gestae, talks about contemporaneous statements, the other one being dying declarations, and the other one being statutory exceptions. Now, in this particular case, at Section 14B, it created a statutory exception so that computer-generated records, which is hearsay evidence, once it satisfies certain criteria, it will be admissible in court. And then the weight of that evidence will be determined by the tribunal of law, by the tribunal of fact, because the tribunal of law will be responsible for only determining whether or not the evidence is admissible. Now, 14B sets out several criteria in which the evidence will be admitted if it's deemed to be computer records. And, Madam President, it will say that there must be a certificate identifying the document containing the statement. It must give the particulars of the device involved in the production of that document, as may be appropriate for the purpose of showing that document was produced by a computer, dealing with any of the matters mentioned above, and signed by the person occupying a responsible position in relation to the operation of the computer. So therefore, the record keeper will be the one deposing the evidence, stating that yes, these are the true and authentic records of the computer. Now, I see that the Attorney General has now repealed the entire Section 14B of the Evidence Act, and it reads that the admissibility, 1, and 2, the sufficiency, so that goes to weight, both the admissibility and sufficiency will now be determined in accordance with common law. I don't know if the Attorney General, in his winding up, because he didn't get to do it in the piloting of the bill, whether or not he could shed some light on the common law principles with respect to the admissibility of computer-generated records, and really give us some more insight into the rationale with respect to the repeal of Section 14B of the Evidence Act. Because 14B of the Evidence Act, it's very prescriptive. I must admit, it's very prescriptive, but it ensures, Madam President, that the hearsay evidence that is being admitted in the court is in fact authentic and verified evidence, Madam President. Because I don't know if we allow the common law to just prevail, there will be a level of uncertainty, I believe, with respect to the applications that are going to be made by the prosecution, in particular for the admission of this particular type of evidence in the court. Okay. And, Madam President, there are a few other clauses in the bill that I just want to touch very briefly on, because I know my time is quickly running out on me, Madam President. And these are just some very minor housekeeping matters. At Clause 8 of the bill, it proposes to delete the word arrested. I believe we need to include the word and arrested, because it doesn't read properly when you look at the particular amendment here. That is the amendment to Section 8 of the law. With respect to, Clause 16 of the bill, which amends Section 24 of the Act.
Senator Hussein, you have 5 more minutes.
Thank you very much, Madam President. Section 24 of the Act speaks to the the discharge of the accused, Madam President. And it deals with the procedure or the process that takes place after an accused person has gone through a sufficiency hearing and has been discharged. Now, it is settled, and it's in the current law, that the DPP has a power to prefer an indictment, notwithstanding a prima facie case has not been made out against that person, flowing from the powers of the DPP under the Constitution. Now, Madam President, at the amendment which is suggested here at subclause 5, it says that there's a time limit set for the record of the proceedings. Now, this changes the time limit now, because once the person has been discharged, it says that the request, it says, where an accused person is discharged, the master, on the written request of the DPP, shall transmit within 14 days to the Director of Public Prosecutions the record of the proceedings. And if the DPP is of the opinion, after considering it, that the person ought not to be discharged, he may apply to a judge for a warrant for the arrest and for an order to put the accused on trial. Now, subsection 5, right under that, speaks about that this must be done within 28 days. Now, the amendment that we propose here is that the DPP would change the extension of the power of the DPP now to just go for the request of the proceedings from the court, rather than how much time now the DPP has, in fact, to make an application for a request to get the proceedings from the court, Madam President. The ex parte application shall take place within the 3-month period. Again, this is setting timelines to the Director of Public Prosecutions Office, and I just would like to reemphasize my submissions that I made earlier on with respect to the resources and staffing issue at the DPP's office, because now there are very strict deadlines that will be set by this particular law, especially when a scheduling order is issued by the master. And the other one, and that, yes. Oh, and I already mentioned this one to the Attorney General at clause 6, which amends subsection 6, whether or not we have to include the words reasonable grounds for suspecting after at the 1, 2, 3, 4, 5th line of that particular provision. And Madam President, these are the extent of my submissions in this matter. My colleagues will expand further on the other clauses and the other issues that arise from this matter. But Madam President, I must say before I close is that there's a lot to talk about national pride in this country and what constitutes national pride. And I believe, Madam President, that when we pass particular pieces of legislation like this, national pride should not be something tangible, but it should mean that persons in this country are treated fairly and they are treated equally, and that their rights and freedoms and privileges are respected. And I also believe, Madam President, that national pride lies in our judiciary, where persons in this country can get swift and very affordable access to justice. I thank you very much.
Senator Seepersad.
Thank you, Madam President, for the opportunity to contribute to the debate on the bill and act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011. This bill is intended to abolish preliminary inquiries and allow for the conduct of initial and sufficiency hearings by a Master of the High Court. Currently, the Magistrates' Courts facilitates preliminary inquiries into serious criminal matters, indictable offences, to determine whether there is enough evidence for a case to be sent to trial in the High Court. Given the estimated annual volume of approximately 146,000 cases coming before the magistrates' courts, and the fact that the resourcing is inadequate, clearly the judicial system is stretched beyond capacity. Of this number, approximately 26,000 are preliminary inquiry cases. Presently, thousands of criminal cases are stuck in the magistrates' courts, some languishing there for as many as 10 to 20 years in the preliminary inquiry phase. At this phase, the court is merely supposed to determine if there is enough evidence to make out a primary facie case. The available statistics indicates the following backlog of cases. 2014 to 2015, 26,342 cases. 2015 to 2016, 24,745 cases. 2016 to 2017, 25,531 cases. And 2017 to 2018, 27,124 cases. Preliminary inquiry cases alone account for between 77 to 85% of this backlog. Madam President, I would surmise that the court is manned by magistrates who are unrealistically tasked by the current volumes and legal handicaps. So while some citizens have been waiting for more than a decade or two to learn whether their cases will be discharged or sent to the High Court for trial, the victims and their families also are waiting. And they too must have their day in court. The situation is further exacerbated when an accused person is unable to secure bail or is charged with a non-bailable offense. Not only is the state burdened with the costs of incarceration, but the person is denied their freedom in the absence of a determination of their guilt or innocence whilst going through a lengthy preliminary inquiry. With the abolition of preliminary inquiries, about 26,000 cases will be removed. As a result, 43 magistrates in 12 courts will only have to deal with a few thousand matters as opposed to several thousand. The municipal police should now have more time to focus on policing of the environment, while the police force will be left to deal with more serious crimes, as there will be a drastically reduced number of case matters before the courts. Reduction in the volumes alone will not guarantee significant improvement in the administration of justice. The entire system must be adequately resourced with both human, physical, and technological capabilities. Transference of the backlog from the magistrates' court to the criminal courts should not be an option. Based on the provisions in the bill, the Director of Public Prosecutions, DPP, will be allowed to determine whether there is enough evidence to proceed with a trial. The DPP will be getting matters at an accelerated rate and must be able to adjudicate these cases to determine if indictments are to be filed. This will be possible only if the DPP office receives all the requisite resources to effectively and efficiently do so. Given these changes, the prison system must also be prepared to effectively manage the new reality. The prisons should not be treated as the proverbial dustbin. Persons on remand must be able to access all, and I stress all, the programs available to convicted prisoners, and not just one or two programs. The main objective is to avoid persons languishing in remand with no access to tools and skills that will aid in their rehabilitation and prepare them to seamlessly resume their lives. Madam President, I was heartened to hear the Prime Minister say that support will continue to be given so that the work of the Wayne Chance initiatives will go on. The business community also need to play its part. They need to help people who have changed their lives and provide opportunities for them to be gainfully employed. Madam President, I do have some concerns with Clause 5.1b. I'm concerned that properties occupied or controlled by the person named in the warrant, but not necessarily specified in the warrant, can be subjected to search by the police. In my view, there's too much latitude allowed in this measure, which can be abused and which can lead to citizens being threatened, intimidated, and victimized. Time limit. While the master is expected to specify an indeterminate time limitation for the life of a search warrant based on his judgment call, deliberate or otherwise, the master can specify 5, 10, 20 months, I assume, and every day the police can come breaking down your doors. Again, there's room for citizens to be intimidated. Due process requires that the rights of citizens be maintained and warrant extensions can be sought as necessary. It is my belief that humane application of the law is needed. My experience in other jurisdictions is that the face of the law is more helpful and less disrespectful than experienced in our jurisdiction. The initiatives of the Commission of Police in promoting the reporting on social media of a kinder face of the law is encouraging. Madam President, with these few words, I thank you.
Senator Chote.
Madam President, thank you for the opportunity to contribute to this debate. Having listened very carefully to the Attorney General's comments during his piloting of the bill, and particularly to the well-researched contribution by Senator Saddam Hosein. My contribution before this Honorable House today is likely to be quite brief. Perhaps I can do them under headings. In that part of the bill which proposes to provide for multiple search warrants being obtained and so on, I do not have a difficulty with that because it has occurred in the past. It is just that different officers will go to different magistrates or justices of the peace and obtain warrants to search business premises which may be located at different addresses. So it has happened in the past. This is really not something new. I do think, however, and I have constantly pressed for this whenever this matter reaches the stage of debate in this House, I do think that it is important for us to have sufficient checks and balances. I have suggested in the past that accountability means that the person giving the warrant or granting the warrant ought to make a record of what information is given on oath to him or her to justify the grant of the warrant. So that if for any reason someone wants to challenge the issuance of a warrant, there is a proper record which is available, which can be checked, and it also serves as a check on those persons who may be inclined simply to grant a warrant if a police officer comes and raises his right hand and says, I believe that there is evidence at so-and-so place for me to be able to obtain a warrant. I think it protects the judicial officer, it protects the police officer to ensure that he does the right thing, and it also protects the citizen who, if he or she believes that the warrant had been, obtained improperly, that citizen will be able to seek access to that recorded information. I think that check and balance is absolutely crucial, and I would respectfully ask the Honorable Attorney General to see if perhaps it could be included. With respect to named persons attending on searches, well, I had experience of that. I had an experience where a certain forensic accountant purported to show up for a police search many years ago. And he was kindly asked to leave the premises and had to do so because there was nothing which allowed him to be on the premises of the person. He was a trespasser. Now, in that particular case, that forensic investigator really wasn't doing much more than saying, look in that drawer, and that kind of thing. I suspect what the Honorable Attorney General has in mind is perhaps IT people accompanying the police officers. Well, I think for us to be clear, and the law must always be clear, I think, I see no reason why the person going for the warrant cannot name the person who is going to be accompanying the officer or officers. So the judicial officer is quite clear in his or her mind, okay, so you need to have an IT expert accompany you, and the police officer commits to that judicial officer that the person who is accompanying him on the execution of the search warrant is in fact an IT expert, and this is the person's name. I think that can only lend to accountability and transparency instead of leaving it wide open. Because if we leave it as simply someone can go with a police officer, then what is to prevent a possible accomplice, for example, going along on the search and unfortunately tainting the possible prosecution of a case? All of these things can happen, and we need to ensure that the processes are clear and clean. Now, with respect to the filing of witness statements, I think 28 days is really absolutely not enough time for a number of reasons. One, the criminal bar as it exists is tiny. I think the misconception held by members of the public is that because crime is high, it means that the criminal bar is large. That is absolutely not the case. In fact, the contrary is true. So 28 days to file witness statements for someone's defense where you are dealing with a very serious matter, or you may be dealing with very serious matters and very complicated matters, I think on the face of it, 28 days is far too short a period of time. In addition to which, there are cases where we often, in preparing our defense, we have to deal with experts. We have to provide them with material. We have to get their opinions, just like in civil cases. And then we have to reduce what they say into the form of statements, which can be filed in court. So I certainly do not see 28 days being sufficient for the kind of case which requires the input of an expert, as many cases now do. With respect to the section or the clause, if I may just have 1 minute to find it, with respect to I think it is section 20 of the Act, which is proposed to be amended, which allows for no original exhibit or statement to be produced to the court unless the prosecution elects to do so, or the master rules that it is in the interest of justice so to do. I would respectfully ask that the defense be included in that consideration, because at the end of the day, it is the accused person who is on trial. So if for some reason it is significant to the defense to see an original document where it is in existence, then I certainly see no harm for such a request to be made. I don't see why it was not included in the first place. Sure.
May I just ask to the previous point that you made before I get to the other one so I can clarify it? The 28-day position, we propose in the bill that we actually extend that time frame. It's no longer 28 days. It's such other time frame as the master may give. Is there something that I have missed in that? Is there a particular clause that you're referring to there?
Yes. Honorable Attorney General, I'm suggesting that we shouldn't have 28 days as a starting point at all. I think we should have perhaps a 3-month period, but certainly not 28 days, because you see, once you put that in there, you are confining, sorry, Madam President, through you are confining yourself to a starting point of 28 days. The clock starts ticking at 28 days for the defense, and I don't think that that is fair or really practicable in the circumstances. And through you, Madam President, there was another issue, Honorable Attorney General.
I'll look at it a little bit further. Thanks for giving me. I apologize.
Yes, so I was just saying that perhaps we ought to include the defense in that process in determining whether originals ought to be made available. Now, with respect to the revocation of the section or the repeal of the section that deals with computer-generated evidence and the reversion to the common law position. I see that in 2017, the English did it. So it means that basically what we're saying is there's now a presumption that the computer is working well, but that presumption is rebuttable. And there are particular categories for the admission of other kinds of records, business records and public records, as I understand it. Those categories will remain unchanged. So I have a little, I don't know how it has worked for the English, but perhaps the Honorable Attorney General in his winding up might be able to tell us, because I don't know much about computers, and I would imagine that any judicial officer dealing with a case which has computer-generated evidence is not going to be an expert on computers either. So I don't know what can go wrong with a computer which may affect its output. And I suppose there may be any number of things, or there may be very few things. But because I don't know, I think it would be useful for us to find out whether the reversion to the common law presumption since 2017 in the UK has worked well, or whether the practitioners have found that there have been difficulties reverting to the old law. I certainly would like us to have some sort of actual evidence before us with respect to that. Now, Honorable Attorney General, the final thing is this. I think much of what is contained in this piece of legislation can already take place and already takes place in the criminal justice system, and we already do it as part of criminal procedure. The fact that we are creating legislation to allow for it is good, because it means that now we have a law as opposed to the common law principle. We have legislation which says that this is what you should do. So from that point of view, I think this piece of legislation may be considered fairly uncontroversial, subject to what I have said. But there is one point raised by Senator Hosein, and I would be grateful if, Honorable Attorney General, Madam President, through you, if we could have some commitment as senators that the electronic systems upon which we will be relying for the working of all of this, that's to say the FTR, and is it the WELAW system, that these systems are in fact functioning well. Because I think it would be such a disappointment for us to have waited so long for the abolition of preliminary inquiries. And believe me, Honorable Attorney General, at this stage, everybody wants PIs abolished. We are quite happy to get rid of PIs because they are time-consuming. They cause a lot of injustice in many instances to persons who are in custody and this kind of thing. So we are quite happy to support any system which will make the system of justice move more quickly. But we don't want to support a piece of legislation only to hear, oh, well, nothing is really happening because the FTRs, the electronic recording systems and so on, are not up to standard, or they have glitches, or they're not working properly. So I just wanted to make that inquiry of you through Madam President, Honorable Attorney General. Otherwise, I think having regard to what I have said, I think it's quite clear that I support the legislation, subject to the few points that I have made. Thank you very much.
Senator Cummings.
Madam President, I want to thank you for this opportunity to make a brief contribution to this bill. And I think that it is generally accepted by members of the public, by practitioners in the criminal justice system, and indeed by members of this House, that preliminary inquiries should be abolished. I don't think that we have a disagreement on that issue, because we have a lot of information that suggests to us that there are issues with the administration of justice, and we have seen over the last few months the Attorney General and his team come to us time and time again with various pieces of legislation designed to improve the administration of justice in Trinidad and Tobago. We know that the system has significant backlogs and inefficiencies. And Madam President, these changes, we welcome these changes. We dealt earlier on with the traffic matters that was designed to bring ease to the courts. We dealt with the children and family matters. We dealt with judge-only trials. The Attorney General has indicated to us that the number of officers in the judiciary has been improved, that the DPP's office will be resourced, that the police are being resourced, and now with the abolition of PI, this will also go a long way in bringing some relief. Now, I'm no attorney at law, and most of the speakers who went before me are quite distinguished attorneys. But you don't need to be an attorney to understand that we have a problem. And let's be practical about this situation. The length of time that it takes to determine a matter in the criminal courts of this country is just very inefficient, and it does not represent what we would consider timely justice for the accused, for the victims, and their families. We have, it's well known, I think one speaker mentioned before, that we have in the system thousands of matters, some of them as old or approaching 20 years, and still at the preliminary inquiry stage. Now, Madam President, that has to be something that we can call dysfunctional. It cannot be that you are accused of committing an offense or crime in 2019, and that 10 years afterwards or 20 years afterwards, this matter is still at the preliminary inquiry stage. And I spoke on the last occasion dealing with the question of persons who are on remand and who are in prison awaiting trial, some of them unable to access bail and so forth. And to some of these persons may have already exceeded the maximum time for those, if they were found guilty and sentenced, and are still incarcerated and awaiting trial. And so, Madam President, this is a welcome move for Trinidad and Tobago. And the fact that a deadline has been set, Senator Hussein, is not a rush. It is not that, it's called work. This is what the government is about. The government is about making sure that within the given time frame that we do what is necessary to make sure and bring relief to the citizens of Trinidad and Tobago. It's not a question of anything being rushed through. This legislation first passed in 2011, and the fact is that it has not brought any relief to the situation. That is the fact. And so the several amendments, you would know, I'm sure, is really designed to make sure that the final product can bring the relief that is intended. What is the urgency? It is urgent. It is urgent because it affects the citizens of Trinidad and Tobago. It affects real lives and real people. We like to speak about crime and how much crime is affecting us. But the fact remains is we have to take serious steps to make sure that crime is not attractive to those who choose to live a criminal life. Because if you know, and this is what has seeped into the society, that the criminal-minded elements know that even having committed a crime, that it takes forever to go through the criminal justice system. And therefore, we care about the people's business. And yes, we plan to free up the courts to make sure that we can move with efficiency to deal with criminal matters. There are too many people, too many accused waiting on justice, too many victims and their family waiting on justice. The police, in the case of the police, there are some matters where officers started to, even the officers who laid the charge in the first place, have gone to retirement. Some have left this part of life as we know it, and these matters are still pending. And so there is a clause in the bill, as I mentioned, police, Madam President, that I found will serve us well. Right, that's clause 7. And clause 7 of the bill will repeal and replace subsection 8, which will allow for the proof of service of a summons to be made principally by an affidavit made by the constable who served the summons. This would eliminate the need for the constable who served the summons to attend court and to prove service of the summons and so forth. And these measures are designed to make the system more efficient and also to make sure that we have the police doing the work that they should be doing instead of being tied up with simple matters like that. Two senators before me, I think all senators spoke about clause 5. And Madam President, at clause 5, what is clause 5 attempting to achieve? We all know that you may have persons with multiple properties, residential, commercial, office, etc. And therefore, as Senator Chote said earlier on, this is not something that is unheard of. We know that there are people with multiple properties, and therefore this clause will allow the police and the officers of the court to have the warrants done in such a way that it can capture all of the properties that the police require to search that connects or concerns the accused person or the person who the police has an interest in. And therefore, I don't think that there is any need for that sort of panic situation that was, there was some attempt to paint the situation. I know that the opposition has to look at their matters and find some reason to object, but this is not a matter that I think that they need to lose any sleep over. You know, it is not always a chicken licking hen situation in this country. We need to look at the matters that are designed to improve, and where the opposition will really stand out is when they are able to put country first and give support to legislation that is intended to improve the lives of our citizens. Madam President, I look forward to the abolition of preliminary inquiries. I like to follow the news, and there are several matters that we know we have been hearing about in the news, and citizens asking, when will these things ever come to an end? I imagine even the affected persons would like to know that they can see the end of the tunnel in these matters. I imagine that civic-minded citizens who observe what is happening around would like to see these matters come. I imagine, as I said earlier on, the persons affected by these things would like to see these matters come together. The government is determined to make sure that this matter of the preliminary inquiry is abolished and that we can make significant improvements. And Senator Saddam also spoke about the question of courts and where all these matters are going to be heard and so forth. And I'm sure that the Attorney General, in his winding up, will give you some information about that, because I know that he's been doing a lot of work in respect of making sure that the judiciary is well-resourced, both in terms of personnel and in terms of accommodation and equipment, etc. We are on the right track. We are on the right track. We are going to do everything possible, as we have demonstrated, to make sure that crime is dealt with in Trinidad and Tobago. But in order to do that, you have to make sure that several things are working together. You have to make sure the police is well-resourced and organized. You have to make sure the judicial system, that we deal with all the bottlenecks, that we deal with all the inefficiency, and this is what this bill is designed to do. And yes, Senator Chote mentioned it, that you must always have checks and balance. That goes without saying. In the implementation of these issues, you must have that in place. We agree with that. There's no question about that. But the legislation that is required is what we are bringing to the Parliament consistently. It is a holistic approach. It is not any one part being left out. If you observe what has been happening, as I said earlier on, the Attorney General has been bringing consistently different pieces of legislation to address the overarching problem that we have in the criminal justice system. So I think I want to ask all of the members of the Senate today, the independent bench and the opposition bench, let us think about country first, and let us support the legislation to make sure that we have the improvements required in the criminal justice system to the benefit of all of the citizens of Trinidad and Tobago. I thank you, Madam President.
Senator Sobers.
Thank you, Madam President, for acknowledging me and giving me an opportunity to contribute here this afternoon to the Administration of Justice Indictable Proceedings Amendment Number 3, Bill 2019. Now, Madam President, when we were told that we had to treat with this particular piece of legislation, I was a bit astonished, because I thought that we dealt with this, as Senator Hussain and Senator Chote and others may have indicated on previous occasions. But still, as a responsible opposition, anything that we can do to properly vet legislation or bills so that when they end up in the hands of the end users, that it redounds to their benefit, we eagerly awaited to see what the bill would have been about. Now, this issue about preliminary inquiries, I mean, we've spoken about this time and time again. We've spoken about why we are here, what would have existed before, the operations of the courts, how they have stressed the courts out, the idealism that would have been held by a particular individual in 2005 with respect to certain reforms. The AG then, I think it would have been Senior Counsel John Jeremy, as he is now, with respect to the same paper committal proceedings that Senator Hussein alluded to. And Senator Hussein indicated in summary fashion in terms of what actually transpires at the magistrate's court, where all matters begin at the magistrate's court. And as they proceed, if it's an indictable matter or either way and it's elected to go to the High Court, they would have a preliminary inquiry. And as Senator Hussein would have indicated, it would have been thought back then that in terms of having paper proceedings and witness statements simply being filed as opposed to viva voce evidence being given, which means persons going into the box and giving live evidence, it was expected, I suspect, based upon the efficiency upon which our civil jurisdiction operates with the same methodology, that matters within the criminal vein would have operated in a smooth and efficient manner as well. But as I would have outlined on the last occasion when we dealt with this particular bill and matters of this particular vein, that the biggest distinction between civil proceedings matters and how they proceed generally through civil courts and criminal matters is sanction. In the civil realm, there's sanctions that exist for almost every single aspect of a particular direction given by a court. And if persons, litigants, attorneys, even attorneys, as a matter of fact, who disobey the directions of the court, they may very well find themselves being subject to a wasted cost order made by the court. But when you're dealing with criminal matters, criminal proceedings, you don't have those types of sanctions. I mean, I know that we have the criminal rules now where there's some degree of sanction. But in terms of treating with criminal matters, you're dealing with life and liberty. And it would have been thought, I suspect, that to place certain sanctions in a scenario like that may not be the best way to operate. So the outcome was matters actually took much longer passing through the court system than it existed before. And to a very large extent, those matters take that inordinate amount of time really and truly based upon one of the key principles or key facts that Senator Hussein spoke about, which is the actual filing of the documents. Now, I would want to go further by saying that preliminary inquiries, the failings or the failures of preliminary inquiries are not only subject to the failure of police in procuring witness statements. I mean, I try my best to be as honest as possible, and it goes further to lawyers as well to not being ready when matters have to be called, lawyers not being present in court. It goes as far as witnesses not adhering to directions given to them by members of the police service in trying to ensure their attendance to court to be cross-examined. It goes to just the general operations of the court systems in some courts, for whatever reason, being closed on a particular day, or the lack of enough magistrates. So a magistrate may have scheduled to start a particular matter on a particular date, but because another colleague is ill or is out of the jurisdiction, they would have to go to another court to adjourn matters there. So all of these things are additions to the entire sum, or equating to the solution or to the issues relating to the slow pace of preliminary inquiries in this country. And what is proposed here, to be very honest, is as the government has indicated, and even Senator Hussein has indicated, what you are inherently going to do is really and truly shift that system now to the High Court, which we have spoken about on several occasions. I will not rehash that particular situation, save and except to say that by simply removing cross-examination, which in my opinion, having been involved in many preliminary inquiries on my own, cross-examination generally does not take that a long period of time. Especially if you know what you're going to cross-examine about or what you're trying to get from a particular witness in terms of trying to debunk the elements of an offense or if the offense itself has been made out. But cross-examination generally would take maybe a couple of weeks, a couple of days in some instances. So by eliminating cross-examination from the entire equation, you're not going to save the type of judicial time that you are you are proposing to the public. Yes, all members of the criminal justice system are eager for this preliminary inquiry situation to be abolished. But the manner in which it has been rolled out, or the information that has been rolled out to the members of the public in terms of attaching some degree of savings to the elimination of cross-examination will do no good. It will not equate to a shorter period of justice within this new system, and I suspect that we will very well be in the same position that we would have been in times gone. My other issue, Madam President, before I actually jump into the bill itself, is the fact that I think for some time now, many a times when bills come to this House, at least I would want to safely say that we really do try to make certain pieces of legislation better. Some of the comments that we make, if not on the floor, but at committee stage, is really and truly geared towards making the bill a better bill and to make good legislation at the end of the day. So it's a bit disheartening to see that this is the third time that we are going to be treating with this particular bill. And having gone through the bill, seeing that some of the comments that would have been given on the last occasion that unfortunately were not adhered to then, finding themselves within the bill now, I mean, precious time could have been saved and not wasted had those comments been taken on board then, so that we wouldn't have to be in this position now, treating with this legislation at this umpteenth hour, to try to rush to get it dealt with in January of next year. So that, I mean, I thought for a moment while dealing with legislation of this nature, dealing with bills, we were on a roll in this House. I mean, we gave support to the cannabis legislation. Support would have been given to an amendment that we made. Well, we voted. Well, everybody voted on the bill. And support would have been given to the police, the omnibus bill that would have dealt with the security sector. And I thought we were really on a roll. We're going down this thing nice, everybody agreeing, we working, and then boom, Christmas time comes and it's supposed to be very merry. And then we get this bill, which on the face of it, it looks good. It's, you know, well wrapped and whatnot. But when you actually open the present, you're getting this Clause 5 situation, which I will get into very shortly, which is, you know, I definitely, it's something that I think should properly be jettisoned from the bill itself. Now, when I looked at the bill, I looked particularly at Clause 3B, which could be located on page 5. And this, for consideration by the government, I wanted a bit of clarity with respect to the definition of the documentary exhibit by inserting after the word printout the words digital file in any format contained in any device. This particular documentary exhibit, my understanding, I could be wrong, and I subject to the Honorable Attorney General's correction at the appropriate stage, would be the file that the police would be bringing to court for the exhibits in the matter that would be before the court. And I'm wondering whether or not maybe the format which it is contained in should be a format that is approved by the Commissioner of Police, as opposed to just any device that is actually being used. It could very well open up officers who bring a flash drive from home or whatever the case is, and it could very well be that that particular device may have been corrupted or whatever. So if it is an approved device possibly issued by the Commissioner of Police, it may augur well for the police officers. Going down now to Clause 5A, A2, and this is touching with what Senator Hosein and also Senator Chote touched on with respect to, or any person accompanying him, meaning the constable, right? Now, I have been present, fortunately, in some instances when the police have in fact raided certain homes or certain business places. And in situations like that, I can say from all of the raids, well, the search warrants that have been executed where I have been present, and even in matters coming before the court, I have never been made aware, or I have never seen for myself personally, apart from the police officers on the exercise or executing the search warrant, any other individual. Now, I hear what the government is saying, and I also listened to what Senator Chote touched on with respect to the possibility of computer experts coming into the home. Now, I wrestled with that issue because I know in terms of when the police are executing a search warrant to procure a computer device, generally they would remove the device from the location, having already executed the search warrant, police officers alone being present in the home, and then take the device at a secondary location where they will have their experts come and tinker with the device. There may be conversation or a narrative concerning other individuals apart from computer experts accompanying police officers. So what about forensic analysis and persons? But I know that those persons really come onto the scene subsequent to an arrest being made, and they have to process the scene or something like that. So they aren't really present during a search of a location. At least I have not been, I don't know of any situation like that existing. So I wrestled with the fact, so I dismissed the forensic aspect of it, and I wrestled with the fact about a computer expert accompanying the police officers. And in terms of doing some reading on that particular issue, I came across literature to suggest that there are some computer devices that once connected, in terms of the hardware connected to a physical device or something, if not removed properly, the information on the system could in fact be wiped. It's a fail-safe or something like that. So in those instances, it would be best that a computer expert accompanies. But in terms of the actual search itself, I mean, if the search warrant is in fact executed, and you are going to have maybe this one-off situation with a computer expert being actually needed, I would have to in fact agree with Senator Chote that you actually name the individual who would be accompanying the police officer and not leave it open to any other person accompanying the police officer in the execution. I didn't go as far as thinking that there's a possibility that the person who accompanying could be an accomplice. But the fact is you don't want any and everybody involved in the search, because as it pertains to search warrants, which I will get into a bit later on, what I think a lot of persons don't understand is that they suspect that if a search is conducted at a person's home or at a premises, if the search is illegally done, then anything procured from the search will be tossed out as evidence. That is wrong. It does not exist in Trinidad and Tobago. That is a concept that exists in the US, this notion about fruit from the poisonous tree. But in Trinidad, if a search is improperly executed or illegally executed, any illegal item found, the police could still charge the individual. That is the law. So that my issue with this particular section is that the person is in fact charged and he goes before the court. The issue of the improper execution of the search warrant or an individual accompanying the police officer in the execution of the search warrant comes up. It does not dismiss the charge before the court. But when it comes to trial, under proper cross-examination, a very prudent attorney can demonstrate that maybe the device may have been planted because certain procedures may not have been followed correctly. And it has happened in several occasions. So I would want the Honorable Attorney General to consider that as well, too. Now, moving on to the real, in my opinion, offensive part about Clause 5. What this particular amendment sets out to do, in 5.1a, one or more sets of premises specified in the warrant. Now, ideally, again, this is something I would have wrestled with, but I agree with Senator Chote, it happens. Sometimes in executing search warrants at different premises, you would want to ensure that you have multiple officers at different homes executing search warrants, because you don't want a situation where you go to House A and you execute a search warrant at House A, and there are items at House B, and person in House A, before you gain entry to the home, telephones person at House B and tells them, destroy whatever or get rid of whatever because the police, they are here right now. So simultaneous search warrants at several different locations is nothing new. It happens, and there's a particular reason for that happening. But what this particular piece of legislation calls upon the Parliament to approve is where you are going to have a warrant for one or more sets of premises specified in the warrant, right? Which, as I said before, I have no issue. But then when you move on, you have any premises under B, occupied or controlled by a person specified in the warrant, but you do not name the actual premises. And that is where I have a problem. It leaves that level of interpretation open then for any police officer, very few of them who may want to thwart the law as it is intended, to run wild. And we already have settled positions in law as it pertains to search warrants and how they are executed. Many persons aren't aware that as the law stands, an officer can in fact enter a premises or a home without a search warrant. He can enter a premises or a home with a warrant to arrest someone. And if in terms of entering the home or trying to enter the home, the persons within the home refuse to allow the police to enter the home with an arrest warrant as opposed to a search warrant, the police have the rights to break down the door and enter the home, right? The other instances where police can enter homes without search warrants are where the police, as they say, are in hot pursuit of someone. So if they are chasing after a suspect in a matter, they can, and the suspect goes into a home, they can follow that suspect and gain entry to the home. And then they can also enter a home, which again people may commonly see on television, and we call it exigent circumstances, but basically it treats with where persons can enter a home, police officers can enter a home to prevent the commission of an offense from actually occurring. And in terms of my criminal practice, I relied heavily on a text that was prepared by a very learned senior counsel and a senator who sat in this chamber, and that is Dana Sital. And in terms of the text itself, which is the Commonwealth Caribbean Criminal Practice and Procedure, the 5th edition, at page 40, there's learning with respect to entry, and it indicates that there has always been a common law right of entry to anyone to break open the door of a house to prevent a murder and to arrest the offender. In Swallows versus Cox 72 Criminal Appeal, paragraph 174, the English Court of Appeal defined 4 situations at common law where the police may enter premises to effect an arrest. They are to prevent a murder, to arrest a felon who had been followed into the house, to prevent the commission of a felony, and the right to the police to follow an offender running away from an officer. Right? The section 3(6) of the Criminal Law Act, chapter 1004 of Trinidad and Tobago also contains this power in respect to arrest for arrestable offenses. So those are the instances where persons can in fact enter homes without search warrants to, in terms of gaining entry to a home. Now, so that it isn't, and I think in terms of the discussions that I've been hearing from persons within the public's domain, I don't want it to be a fear-mongering situation, but what I want the public to understand is the manner in which this has been ruled out. It can, in fact, create fear on its own. It can pick up its own legs and run amok if persons don't have the proper checks and balances implemented at this particular stage to manage how the development of search warrants in this country is ruled out. There's no definition really and truly, save and except for what I suspect may be in the common law or in some other case law, to define occupancy and control. I would want to think that when we're dealing with occupancy and control, we're talking about legitimate occupancy and not just simply a person passing through. When we're talking about control, it must be legitimate in terms of some type of lease or deed or title being procured to demonstrate to the master that this is a person who has a significant degree of control over that particular premises. And then the act, the bill, when it goes further, it's at clause 51AB. It speaks to the justification now in making the application under B. It speaks to, because of the particulars of the indictable offense referred to in subsection 1, there are reasonable grounds for suspecting that it is necessary to search premises occupied or controlled by the person in question, which are not specified in the application for the search warrant, in order to find anything referred to in paragraphs A to C of D. Reasonable belief, of which the suspect is named, but the premises isn't. What information is really going to be brought to this master to make that decision? The suspicion alone for a suspect possibly being in control of a home that you do not know is insufficient information for someone, a judicial officer of that rank, to make such a decision. And then when you move further on...
Senator Subas.
Yes, please.
Honorable Senators, the sitting will be suspended and we will return at 2:15 p.m.